Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
We're back. We're back for the afternoon sesh of day 4 of the Sarah Boone trial. We saw 14 witnesses for the prosecution, who is the state of Florida, and 6 witnesses, including the defendant, Sarah Boone, for the defense so far, and 1 expert for the defense. All right, 1 expert. Dr. Michael Brannon, who talked about battered spouse syndrome in general because he did not evaluate Sarah Boone. And then we saw 2 law enforcement officers testify this morning with regard to prior incidents of DV that they responded to at the home of Sarah and George, in which Sarah was arrested for one of them, despite the fact that George, she had marks on her and George had marks on him as well. And then the second incident, George was arrested. That's the one where Sarah alleges that he stomped on her eye. We saw those horrific photographs of her black eye yesterday. Defense called Detective Chelsea Copsell back to the stand to talk about a statement that she took from Mr. Moreno, who is the maintenance man at the apartment complex, who testified, I think, on day 1. And the testimony elicited from Detective Goddess Chelsea, aka Jacqueline Smith from Charlie's Angels, if you know, you know, was that the maintenance man, Abraham Moreno, told her that Sarah had said to him that George had dragged her down the stairs by her hair the day before his death, and that Sarah told Abraham she was going to teach him a lesson, and it got out of hand, and then she fell asleep when he was in the suitcase. Then we saw the doctor, and then they called back the cell phone forensics expert, Junella, and she was able to authenticate 2 videos that came off of Sarah's phone with regard to George smashing the television with the bat. And thank you to the viewer who went back and watched the medical examiner's testimony to let me know that that was in fact a tattoo on the right side of George's neck, so they were not bruises. We straightened that out, so we have that. Court is still on break. Sound is not up yet, so never fear. We're all here. Did everyone take a little break? Oh, that's my girl. Joanne says, the reason you didn't get the mom role and it ends with us is because you look like Blake Lively's sister. Oh, thank you so much. Not her mom. Not her mom. Thank you. Thank you. That's very sweet. Yeah, remember everyone, you got to smash the like button when you come back in for the afternoon sesh. Even if you did it this morning. I made Pop-Tart emojis due to public request. And some people said this morning, I don't get the Pop-Tart emoji reference. Sarah Boone made a motion for snacks. Her attorney made a motion so she could have some snacks. And among the snacks that she wanted were Pop-Tarts. They said no. I'm like, give the girl a damn Pop-Tart. Like, really? And we also have the Dr. Pepper emoji for this trial because Sarah, all she wanted was Dr. Pepper when she was being questioned outside the apartment after she says she tried to do CPR on George's body. Rest in peace, Jorge Torres. Always about the victims. Always about the victims. The barbed one didn't change outfits, so if Sarah did, you're going to feel self-conscious. Don't. I don't know. The judge may already be back. Oh, are we behind? Oh, thank you. Thanks for telling me. I was somehow it rewound itself to the bottom of to earlier in the day. Thank you so much. Sound's not really up yet, though. Is it me or does Dr. Pepper taste like pepper? Asked Kelly. I don't know. Maybe that's why they give it its name. Maybe it has a pepper sort of flavoring. Dr. Pepper and vodka, is that a drink? That's interesting. Very interesting. Oh, so here's something interesting, Robbie, since you brought this up. I can't remember now what case this is in because I've read the documents on all of them. I think it's, okay, so there's another case in Norfolk County in front of Judge Bev Canone. It's the case of Dr. Turk, who is alleged to have killed his wife, put her body in a pond behind their house or near their home with rocks in her pockets. There was a motion made by the defense to exclude the code word popcorn from the trial. Very interesting. She had a code word, allegedly, popcorn, that she would text to people if she felt in fear of him. Just reminded me of that. Code word popcorn. I'm not sure how to pronounce this. Laxuttle. I went back and watched the TV smashing video. It seems he's asking her to help clean up the mess after smashing the TV, almost like they're agreeing on it together, just in my opinion. She did testify about it.
All right, thank you all very much. Mr. Owens, if you could see to calling Dr. Harper at this time to advise her to be here at 1:30 for her testimony.
Yes, sir.
What are we going to do until 1:30, Judge? Like code word Haas. Yeah, dishonorable Kim Jong Canone coming in with the hard truths.
I'm waiting for Mr. Owens to return.
100%. Tammy says people don't understand the abuse unless you're an abusive or had been in one abusive relationship. It's a cycle. She testified that she would get him to do things so he would keep his mind busy versus abusing and drinking. Yes, it's real. Whether or not the jury is going to believe her story is another question. Should we eat Pop-Tarts until 1:30? Might have to go find some of those frosted cherry Pop-Tarts. I did not know that was a thing, and I do really like cherry pie. The Pop-Tart flavor that I like is, what is it, maple brown sugar? Because I just never knew there was a frosted cherry Pop-Tart. You guys enlightened me in so many ways.
Without Mr. Owens? Sure.
It's just one of them. Diplomatic diva. Whoa. Dr. Pepper is good. Put some respect on it. Yes, I'll allow it. I'll allow Dr. Pepper, but not Mr. Pibb. Can we agree on that? Just like I'll allow Dr. Coke, Diet Coke, but not Diet Pepsi. I don't really drink soda at all, but if I was going to have a Diet Coke, it would definitely be a Diet Coke. And if it was, if they only had Diet Pepsi, I would pass on that. New Hampshire was into the blueberry frosted Pop-Tarts. Many people in the chat put butter on Pop-Tarts. I had no idea that was a thing. Toasted Pop-Tarts with butter on the back. With a butter back. Huh.
All right, as we've discussed, we are not going to be having the charging conference regarding the jury instructions at this time. That will be conducted tomorrow. I have requested the defense to provide any instructions that they are seeking to be provided to the court and to the state in Word format tomorrow, including but not limited to 3.6F or 3.6G and any portions thereof that the defense is seeking to utilize for the purposes of jury instructions. The court throughout the trial has been redlining the jury instructions that were provided initially by the state. At the end of the evidence and testimony presentation this afternoon, the court will email those to all parties. Once Mr. Owens comes back in from advising witnesses of when to be here, we will bring in our jury and proceed with the evidence presentation this afternoon. State, anything else we need to address? Defense, anything else we need to address?
No, you are.
All right, very good. As soon as Mr. Owens enters, we'll bring in our jury.
That sounds good.
The deputies will assist Ms. Walker in the wheelchair into the jury box.
You think Mr. Pibb, you think I'm cheating? You think I'm being unfair to Mr. Pibb, Robbie? Just going to mute that while we wait because the background noise in my headphones is, enough. In my opinion, ask 5 lawyers for an opinion and you'll get 5 different opinions. The jury instructions may be, aside from the evidence of the videos, the most important thing in this case. The jury instructions are going to be vital here. Because so many of us are having just such a hard time with the battered spouse versus the was it intentional that she left him in there? Did she mean to kill him? Did she pass out? Did she fall asleep? Was there an overt act? The jury instructions are going to be critical here. I do not envy the jury's position in this case whatsoever. I thought that attorney just blessed himself. I don't think that's what he was doing, but I kind of like it. Excellent, Jenna. Excellent question for the chat. If there was a Pop-Tart named after Sarah, what would it be? I'll allow it. Buttered Pop-Tarts and vodka pepper has me questioning whether I'm hanging out with the wrong crowd. Oh, no, you're right. You belong. Dishonorable.
Defense, do you recognize our jury?
Yes.
All right, everyone can be seated. Thank you. Members of the jury, again, welcome back. I hope you enjoyed your lunch. I see juror number 5th from the right to left, second row. His hand's already up. He knows what's coming. If you can, just raise those hands, confirm you comply to the court's instructions. Record reflect all hands have been raised. All right, members of the jury, the defense is going to continue with their evidence and testimony presentation this afternoon. Thank you. Mr. Owens, you may call your next witness, sir.
Your Honor, the defense calls Mr. Beryl Walker.
Mr. Pibb is the Howard Wolowitz of Dr. Sodas. I think somebody said, when do you think the jury will get the case? Perhaps tomorrow afternoon. That's what I'm thinking. Unless they're going to put a lot of rebuttal witnesses on. Meaning the state. This is what I think. Oh, hi, Jilly. Hi, Jilly. It's not over. The defense case is still on. We heard a doctor this morning. We saw some video of George smashing a television with a bat, the same exact bat that Sarah used to push his hand back into the suitcase. Also, remember she shook the suitcase too to get him back in there. He's a little chilling. Notorious Pop-Tarts. That's it, Emily. Emily, I don't even know if I have to go any further. If a Pop-Tart were to be named after Sarah Boone, what would it be? Notorious. Or Sour Cherry. Is Rusty Trike. Sunday Fun Day Pop-Tarts. Oh, you guys are good. Crazy Kings. Looney Tunes, Narc chocolate. Well done. Stupid is not a flavor, says Michael. Dr. Pepper Pop Tarts. Well done. Woodbridge Pop Tarts. Excellent. You guys are the funniest chat on the internet, and you know it. You know it. You own it.
Ms. Walker, can you raise your hand and speak bluntly? Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Second-degree murder, Cindy.
Thank you.
Ma'am, good afternoon. Can you
Depraved
state
heart.
and spell your name for the record for us?
What did you say?
Can you state and spell your name for the record
Beryl
for us?
Walker, Bearl, Walker, Walker.
Thank you very much, ma'am. Mr. Beck, you may proceed.
Good afternoon, Ms. Walker.
Does not look happy to be
Ms.
there.
Walker, do you know the defendant, Sarah Boone?
Yes.
How do you know her, ma'am? How do you know Ms. Boone? If you can't hear me, just ask me to repeat myself. and I'll
Okay,
do so.
okay.
How do you know Ms. Boone?
She lived in the same apartment building that I lived in.
And can you tell us how long the two of you shared the same apartment complex, apartment buildings?
About 4 years.
And how is it that you became familiar with Ms. Boone?
My husband and I was sitting out on the porch, and we see her coming with her 2 dogs.
And what happened then?
Then I would call her over
Nice.
with, with her dogs.
And what do you mean by call her over?
When I see her walking with a dog, and I see her and I look at her, and I say, "Hey, Sarah, how you doing?" And that's it.
And would she generally respond to you?
Yes.
And how, well, no, I won't go there. Would you spend time with Ms. Boone?
Did I spend time?
Would you spend time speaking with Ms. Boone?
Yes.
How long would you speak with her?
About 15 or 20 minutes. That's all.
And was your husband sometimes involved in those conversations as well?
He just say hi.
So you and Ms. Boone were the 2 primary communicators?
Yes, sir.
Okay. In the time that you knew Ms. Boone, did you witness anything about her person or her body that gave you cause for concern?
Sometimes I would see it like she had been choked around her neck or her arm be hurt. Have a mark on her arm. And I just asked her.
And would she describe how that happened?
She just say, I had a,
Hey, hang on. The objection is sustained.
Oh, because it's hearsay.
When you would ask her that, how did she appear to you to respond emotionally to your questions about her injuries?
she just say, one of them days or something.
Objection sustained.
It's hearsay. She's not allowed to say what Sarah
Just
said.
for the record.
She can only
instead of
say her
telling-
observations, but this witness, first of all, she's so adorable. And she's in a wheelchair. She's coming into court like she's doing this. She's coming in willingly. They probably didn't have to subpoena her. I would imagine that they didn't. I'm getting wicked. My Boston friends are rubbing off on me. Wicked My Cousin Vinny vibes. Do you remember the witness and My Cousin Vinny with the glasses, and the glasses were really thick, and she came in and they were questioning her about how far away the guy was, like, or what the guy looked like from so far away, and she didn't have her glasses on, right? My Cousin Vinny has entered the chat. She's adorable. She's not allowed to testify about what Sarah told her or what Sarah said, only about her observations. But that last answer sort of snuck in. Let's take it back for one question.
She just say, one of them days or something.
Objection sustained.
Can't unring the bell. One of them days.
Just for the record, instead of telling us what she would say, would she demonstrate any emotion on her face?
Well, I would see the emotion that she was upset about something.
And did you ask about her obvious upset persona? Her upset, the fact that she was upset? Would you ask her about that?
Yeah, well,
Okay, you have to just limit your answer to the question. would you ask her about that issue? About why she was upset?
Yeah.
Okay. I'm sorry, I just can't go beyond that. Thank you. Now, how frequently would that occur?
I would say on the weekends when I see her.
Was that primarily when you saw her on the weekends?
Mostly I would see her walking through, going to her place. And I'm sitting on the porch and I see her then.
After Fun Day Sunday?
Now, strike that. While you were there in that apartment complex, and excuse me for getting ahead of myself, do you still live in that apartment complex?
No,
Oh. How long have you been gone from that apartment complex? If you don't know, that's fine.
oh, it's been a while.
Thank you, ma'am.
What a sweetheart.
During the occasions that you had to interact with Ms. Boone, how did she treat you?
Objection. So
She was a nice lady,
overruled.
nice to me.
Did she ever
Overruled.
act uppity?
Objection. Relevance. Overruled.
Did
Uppity?
she ever treat you in an uppity manner?
What you mean, sir?
Did she ever
She's-
look down on you as a person?
Oh, no,
Did she ever treat you with disrespect?
no.
I'm going to object. This is character evidence. Sustained.
May I approach on this?
It
Your
is
Honor?
character evidence to an extent. Good day today, Pop-Tarts. Samsonite smash those tiny fingers, Pop-Tart. I love this witness. I think this is my favorite witness of the trial. Her name is Beryl Walker. She lived in the same apartment complex with George and Sarah. And she said that she would notice choke marks around Sarah's neck and bruises around her wrists. And when she would ask Sarah what happened, Sarah would say, just one of them days. That was objected to, but you can't unring that bell. Chickens to crochet needs Pop-Tarts now. Hashtag Instacart. Thank you. When I was, it's so funny because when I was looking for a photo of the Pop-Tarts to make the Pop-Tart emoji, that's where it came up was Instacart. And I'm like, I've never really used Instacart. I could order Pop-Tarts right now for $4.75. Well done to me and you and to the Rage Crochet Club. How are you guys doing? Is the Rage Crochet Club in session? We have one member here. We have a Rage Crochet Club for those of you who are new here. In case you're interested, thanks, Izzy, for becoming a new member. Welcome. And Cynthia, 1880, thank you so much for your $20 super sticker. I appreciate you so much. Pop Lock Tart. Yeah, the Woodbridge Pop Tarts seem to be a popular one. Oh, Jilly works for jerks. I'm just kidding. You got to do what you got to do, girl. You got to call in with an eye problem. I can't possibly see coming to work today. Ba-dum-bum. Notorious sour grape. Well played, Steve Kelsey. Well played. Remember, the Rage Snark Club is always accepting members. The Crochet Club and the Snark Club. We're the Snark. You're the Snark Tank. The chat is the Snark Tank. Oh, Cherie, thanks for gifting 5 memberships. And for those lucky souls who have been gifted those memberships, Bobby and Gizmo, Dobean's Mama, Stace, Just Me. Welcome, welcome. I just saw there were some new filings that dropped on the Karen Reed civil case. If anybody would like to hear about those later, I'm taking requests. So you're rage knitting. Rage knitting. Debbie is rage knitting.
Objection sustained.
I'll allow it. Happy birthday to Sylvia's daughter. Happy birthday, Sylvia's daughter.
I'm sorry, I'm back, Mrs. Walker. In the time that you and Ms. Boone lived together, on occasion, did you see law enforcement arrive at the apartment complex?
A couple of times.
And did you ever get involved in any of their investigation?
No, sir.
Were you ever approached by law enforcement and asked for information, evidence, insight into what might be going on?
No, sir.
Now, in all candor, were there occasions when you believed that Sarah Boone may have been under the influence of alcohol?
No, I can't say.
Did you also observe Jorge Torres during the time that you lived there in the apartment complex?
I didn't see him very much. If we sitting on the porch, that's the only time I see him.
Did you know Mr. Torres very well?
No.
Was there an incident when you saw Ms. Boone with a black eye?
Yes.
Did you witness a pattern between Ms. Boone and Mr. Torres wherein you observed signs of abuse?
Objection, nomination.
Sustained.
You testified that you saw Ms. Boone on occasion with bruises, other injuries, and a black eye. Is that correct? Is that accurate?
Yes.
And was there any pattern to what you observed in regards to those injuries and bruises that you observed on Ms. Boone?
One time I seen with a black eye and like she had been choked one time.
Okay.
I wonder if that was the same time or two different times. I mean, she might get my vote for witness of the
Did
year.
Ms. Boone complain to you
Of all
about
trials.
those marks?
Did she complain to you about these marks?
Yes.
Thank you, Your Honor. Nothing further.
Any cross-examination?
Hi, Ms. Walker.
Oh,
Is it fair to say you're not sure when exactly you saw any of those injuries on her, correct?
say that again?
You're not exactly sure when you saw any of those injuries on her, correct?
Once she come past the apartment, I'll be sitting out there because we always sit out there.
Right, but we don't know if this is December or 2018 or anything
I
like that.
can't remember, sir.
Okay. And is it fair to say you have no idea how she got those marks? Is that fair?
Repeat that again?
Do you have any idea how she got those marks?
On the weekends, I see him and her go in.
Okay. But you don't know who, if anybody, put those marks on her, right?
Well,
Just calls for yes or
I
no.
can tell when they must have had an argument or something. I hear the dogs barking.
Okay. And you're 5 doors down, right? Unit 8, Unit 3?
Mr. Harper, but in a good way.
Yeah.
No other questions?
Any redirect examination?
No, Your Honor. Thank you.
Can this witness be released?
Yes, sir.
Thank you very much, ma'am.
You don't know exactly when, do you? You're
Ms.
not,
Walker, the deputies are going to come get you and take you out,
you're
okay?
not gonna rattle Beryl
You all
Walker.
done?
Yes, ma'am.
You are
Thank you so
not.
much.
She's like, I'm all done. Look at her. She dressed all up to come to court. She had to get there somehow with her wheelchair in an ambulette. Who knows how she got there or who knows? They were not going to rattle her. She was adorable. Probably shouldn't have crossed her. Agreed. Just because she doesn't remember exact dates when she saw the black eye and the choke marks, that was a very helpful witness for the defense, in my opinion. She may get my vote for most truthful witness of the year. I think at the end of the year, we're going to have some awards for the witnesses in the trials that we've watched together. Because outside of Lucky Loughran and the Karen retrial, this may be the most, I think, truthful witness that we've seen this year. Let me know if you have any other nominees. It's only October. Backs up Sarah's claims of abuse. And according to her, the only thing Sarah said to her was, oh, just one of those days. She never said, George is choking me, George is beating me. And that's not uncommon for victims, as you know. Right. No, I didn't write Sarah's fights with George on a calendar. She did say she would hear the dogs barking. So, I mean, I got more out of her. But you lived 5 doors away, right? She was not, she was very credible to me and very adorable. God love her. That's right. She felt she wanted to be heard. She was dressing up and she was coming in. She was going to tell the story. I wonder if she, I mean, obviously, I'm sure she's known Sarah's been in jail for close to 5 years. I wonder if she's felt any sort of remorse about that. Like, oh, maybe I could have called law enforcement or police when I saw she had those choke marks on her neck. Maybe I could have done something. We don't know. Didn't ask her that. Yeah, she didn't even understand her testimony was over. Barbed one. I thought she helped her case, in my opinion. I thought she did. She saw evidence of markings. And it wasn't like Sarah came running over to her and started, you know, talking about how it can happen. She just said, oh, one of those days. Right, goodbye. She sure didn't choke herself. And both things can be true, right, KPC? I believe Sarah was a DV victim, just not that she was in imminent danger. I think both of those things can coexist. And that's why I'm glad I'm not on this jury. Thank you, DMC. That's what I'm thinking. It made Sarah's testimony more credible. Because this witness is a true non-interested party. Not law enforcement, not anybody who's related to George, not anybody who's related to Sarah. Just a innocent passerby who happened to notice some things that she got to testify about. Kind of like Lucky Loughran. Hi, Nick. Thanks for the 10. I feel so weird, but for some odd reason, I'm starting to kind of like Sarah Boone. I like her demeanor in court. I feel like I could have hired her. She seems diligent and competent for a layperson. And the poster that she made advertising for a lawyer was really good, right? Don't feel weird about it, Nick. We're here for you. We'll allow it. This is one of those cases where I am very, unlike me, I'm undecided still at this moment. Somebody came into the comments and they were saying, they were like yelling at me in my comments about.
All right, members of the jury, witness is running a couple minutes late. I think they may be stuck in the security line downstairs. So we're just going to be in a short recess for them to join us this afternoon. Similar instruction that I've given you, please do not conduct any independent investigation or research regarding the person, places, things, or charge involved, and do not have any discussions amongst yourselves or anyone else, and we'll bring you back in as soon as that witness arrives. Thank you again for your patience.
All right, we have a little bit of time. Somebody came into my comments and was yelling at me like, you can't say that the Menendez brothers, something about the Menendez brothers comparing them to Sarah Boone. Like, it's the same thing. But I'm thinking to myself, I didn't snarkily reply. The Menendez brothers have been in jail for 34 years. Okay. It's a completely different case, in my opinion, from Sarah Boone. It's like apples and oranges. You're talking about 2 young boys who were allegedly raped by their father for years. And we're talking about a really hammered woman who was maybe the victim and perpetrator of DV, who may or may not have zipped her. Well, she definitely zipped him in the suitcase. Whether or not she intended to kill, like, this is just 2 totally different things. Like, don't even, like, how do you even, sometimes people just want to fight. The other thing is that apparently there's going to be a decision on the Menendez brothers by Friday. So there's that. I did a show on that we watched the press conference together live. And that was interesting. Hold on a second. Okay, the Torlina Fields in Kentucky, the woman who is accused of chopping up her mother and cooking her in a pot and eviscerating her, and her organs were found all over the backyard. And she was supposed to have a preliminary hearing today, but it was adjourned until mid-November because it has now come out. How many of you have been following that case with me? It's a crazy case out of Kentucky. She was casting spells on people and acting belligerently. And then the next day, the workers showed up and they found the mother's body in the backyard in pieces somewhere in the oven in a cast iron pot. It has since come out that the sister, 2 days after Torlina's arrest, after the mother's death, the sister filed a protective order against the brother, saying that he's the one who killed the mother. And if she winds up dead, he's going to be the one who killed her. And he lives in California. And it's a crazy, crazy story. It's getting crazier. So go back and watch my first video on that. It's really interesting. It wasn't a very long show. But apparently now it may have something to do with the brother. I have to just jump for 1 second because I think my sprinkler guy might be here. And I forgot that he was coming today. Just give me a second. I will be right back. Okay. Yeah, we're on break. We're waiting for we're double dipping. We're waiting for another witness to show up, and I'm not sure. Life is going good when you have a sprinkler boy. Somebody has to turn the system off. I don't know how to turn the system off. Maybe I would I could probably look up a YouTube video on that, but I mean, come on. No time for that. I don't. Vicky. Oh, they went on a break. Well, we're just waiting for the next witness to come up. The case I just spoke about regarding the girl cutting up her mother in Kentucky. She's 28 or she's like 32. I got a guy, little cupcake. You know, I got a guy. You got to get a guy. Got to get a guy for that. You got to get a guy. I got a guy. You need a guy. I got a guy. You need a guy. You need a guy. You need a guy. You need a guy to fix your dent. I got a guy. You know how to guy? You know how to guy to fix the dent on John O'Keefe's car? They got a guy for that. Need a guy to smash your taillight and sprinkle some taillight pieces on his crime scene? We got a guy. We got a guy for that. Need a guy to take the fall? Need a guy to take the fall? You want to pin it on the girl? We got a guy. We got a guy for that. Yes. You like my cup? Oh, I thought it was my my Colorado Buffs, but no, this is just a Dunkin' cup. Just a Dunkin' cup. I'm a Dunkin' girl. Dunkin' beats Starbucks any day of the week for me. Coffee wise, I do like Starbucks has good iced matcha. I'll allow it. I'll allow iced matcha from the as such Dunkin'. Thanks again, Cynthia, for your super sticker. Chickens to crochet. Thanks for becoming a member. And Cherie gifted 5 memberships. I believe I thanked you already, but I did not delete. So you get 2 thank yous. Grateful Glow 1111. They now make bite-sized frosted Pop-Tarts. Why? Why do we need to mess with perfection? I do not want a bite-sized Pop-Tart. I want to have a Pop-Tart that I want for myself. The right size that I want. The size that I want. I want to bite it the way I want to bite it. It's like New Coke. Why did they make New Coke? You don't mess with perfection. They lost a lot of money on that New Coke, remember?
Cameras showing attorneys' laptops. It's been brought to my attention that that is going on again.
Ooh, hold on a second. Listen. Always paying $5 dues for snark.
We are back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Judge, before we began trial, I had indicated that in the past, historically, as cases, there were problems with cameras showing attorneys' laptops. It's been brought to my attention that that is going on again. I'm asking the court to order whoever it is who has a camera, whether it be phone or the court TV pool camera, that they not do that.
Okay. All right. Members of the gallery, good afternoon. And the TV crews as well. Information that's contained on both parties' laptops, be it the defense or the state, is protected by work product and attorney-client privilege. It's not something that's viewable, not something that should be disseminated, and not something that can be looked at unless there is a knowing, intelligent waiver, and that stuff's going to be put out to the public for consumption. So I'm going to ask you as best as possible not to view, take pictures of, or look at any of the laptops, be it the defense's laptops or the state's laptops, to avoid that. With regard to the camera, if we can, when zooming in on either the defense counsel's table or the state's counsel's table, if we can try to avoid their laptops, I would greatly appreciate you, sir. And the podium. Thank you.
Yeah, they will ban the courtrooms. They will turn off the fan. They will turn off the air conditioning. You don't do that. We saw them doing that. Also, zooming in on attorney-client conversations during the Karen Reed case. You don't do that. The pool photographers need to learn better or they're going to get banned from the courtroom. You know, we get so mad when they don't allow cameras in the courtrooms, like in Delphi and New York New York never lets cameras in. And if this is the way they're going to behave, and these are very experienced, I mean, all they do, these networks, is report on trials, you know? Law and Crime, Court TV. Don't do it. You're really going to make the public mad. They're mad enough at mainstream media. Don't do it. Thanks, Jenna B. 127 for gifting a membership. I appreciate you. Linda, thanks for being with me for 4 months. Says hit the like button and subscribe. Thanks for all your coverage on trials and documents and a great job, mods. Yeah, the mods are the best. Mods are the best. Nick, we covered that. Thank you. Sandra, thanks for tuning in. Thanks for the 5. Says, Melanie, you've created a meaningful, safe space for all keen on the law and humanity. Thank you. Love from Singapore. Oh, love right back to you. Thank you, Cynthia, for becoming a new member. Lorraine, for non-DV people in the chat, something that seems non-threatening to them could very well be terrifying to DV people. We don't know what triggers them. That's right. Thank you, Lorraine, for tuning in from Canada. I'm a baffled gifting 5 memberships, and to you lucky recipients, thank you. And Bath Salt, thank you so much for gifting 5 memberships. You guys are super, super generous this afternoon. Thank you so much. All right, so we go back to waiting now. Do, 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 do. I want the Diddy trial lab, but it's in New York. It's also federal, so there are no cameras in federal court anywhere. But in addition to, so yeah, I mean, like all of the trials in New York that were not covered, Ghislaine Maxwell, Keith Raniere, I don't know if those were federal or state, all the Trump trials, Diddy is federal, so that wouldn't be televised anyway, but the Long Island serial killer is state court, and that will not be televised. They won't even allow a video camera in the courtroom for the hearings, only a still photographer, a pool photographer for still photography. The judge is very respectful, Olinka.
All right, we are back on the record.
Back on the record.
Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Fitzgerald on behalf of the state.
Defense.
James Owens on behalf of Ms. Boone.
Tony Henderson for Ms. Boone.
Kevin Beck on behalf of Sarah.
All right, Ms. Boone is standing at counsel's table wearing a dark gray suit and maroon blouse. Let's go ahead and bring in our jury as Dr. Harper is here.
In real time? Those are law students standing with the judge. They're on his mock trial team or moot court team at the law school that he teaches at, and he's allowed them to stand next to him during the trial, and they're very lucky to be here. Thanks, Melissa. Yeah, everybody needs to hit the like button. We're up to 1,726 amazing Snark Tank viewers. Right, Jennifer? George did not have to die.
All rise, jury dinner.
First thing we see is a laptop. Wow. I'm going to rewind it because he's going to have to talk to the jury anyway. And then, there it is. Yep.
Blouse. Let's go ahead and bring.
Did they not understand the assignment? They were just chastised. Come on now.
Instructions. Record reflect instructions. Record reflect all hands have been raised. All right, defense. At this time, you may call your next witness.
We call Dr. Julie Harper.
Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Doctor, good afternoon. Could you state and spell your name for the record for us?
Dr. Julie Harper, Harper.
Thank you. Counselor, you may inquire.
Thank you, Judge. Good afternoon.
Good afternoon.
I think you've already stated your name, but just introduce yourself to the jury.
My name is Dr. Julie Harper, and I'm a licensed psychologist.
Would you tell the jury your educational background?
I have an undergraduate degree from Oberlin College in biopsychology. I have a master's degree from University of Denver. I went on from my master's degree to earn a psychological doctorate.
Shout out to DU. That's my law school. I'm going to be right back. The sprinkler guy's here, but I will be back. So don't freak out. I did not swipe out. I will be listening on my phone so I can come back and make my snarky comments as soon as I get here. Talk amongst yourselves, but be good for the mods, peeps. All right. Love you.
That's called a PsyD. That was also from University of Denver. In completing that education, I specialized in psychological assessment, which means I had extra coursework in that area of learning to administer psychological tests to other people. I completed an APA-approved internship at Washington State University, which means that I was matched, and that was my site to practice being a psychologist for a full year, and that was between 1999 and 2000. And following that, I turned in my dissertation, which was in the passing of power in couples relationships. I then graduated and started my postdoc work. in Pullman, Washington. As part of becoming a psychologist, you have to have over 1,500 to 2,000 hours of supervised work as a psychologist. The person that supervised me was a forensic psychologist. So during that postdoc time, that was my introduction to forensic work while I worked at a community mental health center.
Dr. Harper, how long have you been licensed?
I was first licensed in Washington State in 2002, so 22 years.
What type of position have you held as a psychologist?
Well, I was rehired at my internship site, so I worked at Washington State University College Counseling Center. I also worked 2 times at a community mental health center. The first time was in Pullman, Washington, and that was during the period of time where I was getting my postdoc hours completed, and then I stayed on after licensure. I also worked in Florida. When I came to Florida in 2005, I took a position in the Fort Walton Beach area at Bridgeway Center, which is a community mental health center. And while working there, I completed a variety of psychological assessments. I was directing the testing program. I also began working during the Department of Juvenile Justice contract work for evaluating adolescents that had gotten into legal trouble and needed an assessment for consideration of program placement. I worked in that community mental health setting doing clinical assessments and the DJJ contract and Social Security evaluations, and continued that until about 2010. In 2010, I opened my own private practice, which is Northwest Florida Psychological Services. And in the beginning of the practice, it was a combined clinical and forensic practice, meaning that I spent a majority of time doing psychological assessments to answer questions from physicians about things like ADHD, depression, to make treatment recommendations. I had the therapy patients, and I also did, again, Social Security disability evaluations, so numerous kinds of assessments. And then over time, I began doing more and more forensic work, including receiving appointments from judges to do competency to stand trial evaluations, sanity at the time of the offense evaluations for Circuit 1 in Florida. And I continued to do the Department of Juvenile Justice contract briefly, but then that it came up for bid and I discontinued that contract. What I did is I slowly reduced my clinical practice, because when you do forensic psychology, it means you have to travel. Your individuals that you're seeing are not usually out in the community. A lot of times you have to see them in jail. So it's hard to maintain a therapy practice, and I scaled that back over time. Eventually, my practice became entirely forensic. And then in 2017, I took a job with the state of Georgia to be an evaluator full-time. I was working doing competency to stand trial and sanity at the time of the offense evaluations, and then assisting with risk assessments in the inpatient setting. I did that until 2021. At that time, my private practice was just quieted down, of course, from COVID, and I was not in full-time practice. So I wished to return to full-time practice with my own company, and I did that in May of 2021. And since then, obviously the courts are busy again. We're all recovering from the COVID era and back to full-time practice.
Now, where do you live?
I live in Okaloosa County, and that is in the panhandle of Florida.
All right. And is that where your practice is currently?
Yes.
All right. Is it fair to say you travel the state to?
Bless you.
Is it fair to say you travel the state
Bless
to
you.
do assessments or evaluations?
That's correct. I travel to a lot of cities throughout Florida, as far south as like Miami, and then of course working along.
Is it fair to say that you testify in various counties throughout the state?
Yes.
And I know that yesterday you were set to testify in Bay County, Panama City.
That's correct. I was testifying yesterday in a death penalty case in Bay County.
All right. And when you finished, you drove here?
Yes, I did.
My understanding is you got here after midnight.
Yes.
What does it matter?
Um,
I mean,
What other counties have you testified in?
Well, I've testified here in Orange County, in Miami-Dade, in Duval. It might be hard for me to list everywhere. Alachua, Escambia, Santa Rosa County, Walton County, Bay County, Washington.
So just so the jury understands, the nature of practice is you have to travel throughout the state.
Well, I do work in cases where the person is at risk of, succumbing to the death penalty. And so those cases require repeated evaluations in different vicinities. And so I have been, traveling to work on murder cases. There are psychologists, I suppose, that do forensic work that might just confine their work to one circuit or stay, but I actually broadly travel.
Was not at that one. Nope.
You said that your practice is now entirely forensic?
That's
What
correct.
you said? And you've testified about what kind of forensic work you do?
Yes. So as a forensic psychologist, sometimes I am tasked with testifying about something very specific. So for instance, a person's ability to stand trial if they're knowledgeable and can go forward with their trial process. I've testified about a person's sanity at the time of the offense, meaning if they had a mental health condition that met the statute as to not being sane at the time of the offense. I've testified in sentencing hearings. I've been an expert witness for Department of Children and Families. I've testified in vocational rehabilitation hearings as their expert. In what's called social investigation. That's what they used to call custody evaluations. So in numerous capacities.
And would it be fair to say that a lot of times you're appointed by the court to provide the service that you provide and you're paid by the state?
That's correct.
What percentage of your work is where you're paid by the government to do the work?
I would say that the majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. And I realize you testify on occasion by the state, but majority of your time, 90%, 95% of the time, you testify on the behalf of the defense?
Yes, the evaluation's complete and either side can call me for testimony, and the majority of the time I'm called by defense.
And so you make a living by traveling the state, and generally the court system, I think they call it JAC, pays your fees.
So I make a living by performing work as a forensic psychologist, evaluating individuals, most of the time that are incarcerated in a prison or a jail setting, providing consultation to attorneys who might just have questions that would need a psychological expert to explain something to them. I also do fitness for duty evaluations for law enforcement, pre-employment evaluations for law enforcement and firefighters. So depending on the work that's needed, I do those.
Doctor, how is a forensic psychological evaluation different than a regular psychological evaluation? Can you tell the jury?
Sure. So if any of us went into a psychologist's office and had an evaluation done, it would be most likely for treatment. So things like if you qualify for surgery or you're going to have treatment, maybe you've got a condition that you want therapy for. A psychological assessment is very helpful in identifying a diagnosis and then setting a course for treatment. A forensic psychological evaluation has many of the same procedures, but the aim is really different. The aim would be to answer some kind of legal question that is posed. So as an expert, I might be in the position to provide some education or experiential descriptions of something that a person might be suffering from to people that are going to make a decision. So for instance, if it's a competency evaluation, I would educate the fact finder. In that case, it would be a judge about what is wrong with the person or if they had any deficits at all, or if they were competent to proceed. In a situation like this, a forensic psychological evaluation might be geared more to identifying, again, if there is a mental health condition present in the defendant I'm evaluating, and then to provide a jury with education about what I found in my evaluation.
How many forensic psychological evaluations have you conducted? Estimate.
Kind of does matter, Jackie, only because in order for them to qualify her as a witness in this trial, it has to be shown that she's been qualified in other states and other counties or whatever. So it is a little bit relevant, but I'm not from Florida, and those are a lot of the counties she's mentioned I've never heard of. So
just as an estimate, it's clearly more than 4,000. I've been doing forensic psychological evaluations as far back as 2007.
Have you been qualified as an expert to testify in forensic psychologist in court as a forensic psychologist?
I have.
And you said you've testified for the prosecution.
Yes.
And you've testified for the defense.
Yes.
Is there any difference in the work that you do depending on who hires you? Which side?
Absolutely not. A forensic psychological evaluation is an objective assessment of what's going on with the person. So you should be performing the same kinds of procedures in doing the evaluation. It should not matter who's retained you. What you're trying to do is answer a question.
Are there times when you actually do an evaluation and assess an individual, but then you're not actually called to testify?
Yes, many times that's the case. You will provide your feedback to the attorney, and then it's up to the attorney to decide if there's anything in there that would be useful to them, or if they're pursuing a certain kind of information for the court, they would choose to call you for testimony.
Dr. Harper, do you recognize Sarah Boone at the defense table with Tony Henderson?
I do.
When did you first get involved with Miss Boone?
It would have been in around June of 2020. It was the first I heard of her case.
And what were you asked to do?
A comprehensive psychological evaluation of Ms. Boone.
And did you do that in Miss Boone's case?
I did.
Okay. Were you
all the way
given
back in June of
materials to
2020?
review?
I was.
Is that standard operating procedure?
Yes.
Hold on. Were you given what now?
Psychological evaluation of Ms. Boone.
And did you do that in Miss Boone's case?
I did.
Okay. Were you given materials to review?
Materials to
I
review.
was.
Is that standard operating procedure?
Yes.
You assess the client individually, one-on-one, and then there are collateral evidence or material that you also consider?
Yes.
Can you tell the jury about that?
Yes. So in forensic work, there are a variety of documents that are usually available in assessing a defendant. In this case, for criminal court, you would see things like witness statements. There might be body cam footage or just more information about the offense itself. Sometimes there's an interrogation video. So you would get kind of the legal description of the offense and the things that have occurred. I also will often get educational records of a person, mental health records, hospital records, things of that nature that would describe their biopsychosocial history to me.
And you were given materials as it relates to Sarah Boone to review?
Yes, I have been.
How many times did you meet with Sarah Boone?
So 9 times.
All right. Can you tell the jury what you did as part of your evaluation of Sarah Boone?
Well, we had clinical forensic interview in which I reviewed her background history, so her early childhood. I also assessed her with assessments, meaning I administered 3 psychological tests to her. I reviewed her prior mental health records, her interrogation video, some prior information about her legal history. So she had been previously arrested. I reviewed that as well. We had opportunity to review the transcript of her interrogation video. So there were a variety of things that would be considered what I did with her.
Okay. So you considered some medical records?
Yes,
And did you also consider some records from George Torres's records?
I did see his hospital records.
Now, do you consider in doing an assessment and forming any opinions, an individual like Ms. Boone's upbringing in terms of where they grew up and what their family environment was like?
Yes, that's part of gathering their background history, so biopsychosocial information.
And did you consider Ms. Boone's upbringing in forming any opinions?
I did.
Can you tell us a little bit about that?
Yes, so of her history, I found it pertinent that she was raised with,
Conduit 704.
Roach.
I don't know. I would think that her childhood might be relevant here. And hear what the objection is, but they're approaching. Thank you, Lauren, for loving it here. Has anyone in the chat ever been called to testify as an expert in a trial? Just curious. That's a great question, Pregnant Pause. I'm sure if anybody does, they will tell you. They will tell you. You going to Red Rocks? Who's playing at Red Rocks, Barbara? Who's playing? Thank you, I'm baffled, for gifting 5 memberships. Wendy, darling, thank you for your 20. Says DA is kind of a letdown.
The objection is sustained.
I was hoping for a real battle, but was just meh. My dream prosecutor for this case are Linda and or Alan Jackson for second degree. Praying for second degree. Thanks, Melanie. Great coverage as always. Thanks, Wendy, darling. Great. You're a great guest and viewer as always.
Would you have considered, as part of her family background, whether or not some of her family members had passed away early in her life?
Objection, leading Conduit 704.
Sustained.
Objection, leading,
You
something,
considered
something.
the entire family background and history without going into the details of what she said or what you learned from looking at records? I'm sorry?
yes,
And did you consider her relationship with her mother as part of her psychological development?
yes,
Ed Wallace in the house, everyone. The famous Ed Wallace. Forensic.
Now, do you
Forensics
believe
daddy.
that Sarah Boone does have some narcissistic traits?
I do.
She doesn't qualify or meet the criteria for that diagnosis, does she?
I did not diagnose her with that.
Can you elaborate on or explain how you feel that Sarah Boone does have some narcissistic traits?
Well, in meeting with her as part of the evaluation, the narcissistic traits that I identified would have to do with, as she described, being a straight A student. She reiterated about her abilities, and I felt that that was evidence that she had low self-esteem, and her coping mechanism was to identify what made her stand out, and that would be consistent with a narcissistic trait.
Now, I know there's been reference in this case to a manual that all psychologists, all psychiatrists refer to. Do you have that manual with you?
I do.
And what is the name of that manual?
It is the Diagnostic and Statistical Manual of Mental Disorders, the text revision. So it's the DSM-5 text revision.
Now, Dr. Brandon testified earlier today, and there was some evidence relating to when you suffer from narcissism, there's a sense of grandiosity.
Oh, yeah.
But is that from this manual and your studies and your experience, where they require excessive admiration and whatnot, that there's a reason for that?
If I'm understanding your question, there's a criterion in narcissistic personality disorder related to that.
What I'm getting to is many times you may have these narcissistic traits, but really you suffer from very low self-esteem.
That's the underpinning of that criterion.
Would you explain that to me?
If I'm allowed to reference the DSM, then I can explain it best.
All
Just
right,
don't read
I'll allow
from
it.
Just,
All
you
right.
need to review, if you need to read a paragraph and then explain it to the jury.
So based on the description in the DSM, if a person's self-esteem is very fragile and they have low self-esteem, they may require more outside admiration or even appear more grandiose in their abilities because at root, they don't feel secure and confident. And so it's what we would call a defense. And so that criterion is actually a way that a person tries to make themselves feel better.
Anything else you want to say about that issue?
Well, you asked me about why I didn't diagnose narcissistic personality disorder. And again, from the DSM,
Are there criteria?
there are criterion for each disorder.
And so when you're assessing someone, they have to meet all those criteria for you to form that opinion that they actually suffer from that disorder.
Well, the first, I guess, issue is do they have the criterion that are listed? And then the second would be, is there a different mental health disorder that would better explain the criterion that you're seeing? The criterion within the DSM overlap considerably across disorders. And so there are some helpful guidelines within the DSM to remind you of that you may have what's called differential diagnosis. So if you're considering one thing, that you also are directed to look at other things. So that happened in this case, in this instance, that the DSM guided me to also look at other things.
But just for purposes, to make it clear, you did not diagnose her with narcissism, that disorder.
That's correct, because the DSM's description guided me that would not be an appropriate diagnosis.
Why did you not diagnose Ms. Boone with a personality disorder?
Well, first of all, it has to be a pervasive pattern of distorted relational abilities. So basically, if she is demonstrating in a variety of settings that she has these symptoms. And then secondarily, the diagnosis of post-traumatic stress disorder is listed when you're considering personality disorders. The DSM guides you that if there are personality changes that are associated with the exposure to a trauma, then you should consider post-traumatic stress disorder and not a personality disorder.
Have you diagnosed her with anything? And we'll elaborate on that, but through your assessment, have you diagnosed her with anything?
Yes, so she has a diagnosis of post-traumatic stress disorder. She has symptoms of anxiety that would be consistent with post-traumatic stress disorder. So that is an anxiety disorder.
And you feel like she suffers from post-traumatic stress?
I do.
Now, at the time of this event, we're talking February 23rd of 2020, you were aware that she did not have much family support.
Yes.
Doctor, why do you administer psychological testing?
Psychological testing allows an objective measurement of what the person's symptoms may be as compared to sort of an average. So if we can see what the average range on a standardized measure would be for any person, if there is an interpretable difference, that gives me clinical information. So it's not just relying on what the person has told me. I've got an objective measurement that I can compare to other people. And then I also administer psychological testing in a forensic evaluation to help assist me in making sure that the person is intending to put in good effort with me. In some forensic settings, a person may have a reason to present symptoms, like if they're in a custody evaluation, for instance, they might have a reason to minimize symptoms, or they may exaggerate something else. And so assessments as to the person's response to you and if they're validly participating are important.
So there are tests to see if you're faking or malingering or that type of thing?
Right, and so you would call it feigning mental health symptoms when the person is either far exaggerating a symptom they do have, or if they're pretending to have a symptom that they do not actually have.
Closed captions said bling ring, capital B, capital R, bling ring instead of malingering. So don't follow them too much.
Now, as it relates to Sarah Boone, what type of psychological testing did you administer?
I administered the inventory of legal knowledge, and that is a test that has to do with whether or not she was validly participating regarding her understanding of the legal process. I also administered the Miller Forensic Assessment of Symptoms test.
Now, explain to the jury what that Miller Forensic Assessment of Symptoms test is.
So that is also a test of feigning to identify if she's validly participating in the evaluation. So if she had endorsed psychological symptoms or psychiatric symptoms, that would be unusual or not typical of a valid psychiatric patient.
What were the results of Ms. Boone's test on the Miller Forensic?
She validly participated. There was no indication of any feigning or malingering.
And as far as the inventory of legal knowledge case, what were the results?
Again, she was validly participating, and she did not even come close to the cutoff that would put her in the range of feigning.
Can you tell the jury what the purpose of the clinician-administered post-traumatic stress disorder scale is?
Yes. So that would be considered a very useful assessment of post-traumatic stress disorder. It allows me to interview a person about exposure to a traumatic incident and then identify if there's a change in behavior that has occurred as a result of that exposure to trauma.
At the time that you administered that test, did Ms. Boone in fact have post-traumatic stress disorder?
Well,
Or tell me the results. Just
yes. So the results would be consistent with a person having post-traumatic stress disorder. I do not diagnose from one test. That wouldn't be appropriate, but it is consistent with the background and the symptoms that I had previously, taken down during my evaluation of her. So the clinical portion, when we go through symptoms, that was consistent with the outcome of that test.
And would this testing, all the testing, help you determine if Ms. Boone had a change in functioning from before the alleged trauma
Bless you.
to after the
Bless
alleged
you.
trauma? And I'm referring to the trauma. We're going to talk about what the trauma was, but the trauma was the intimate partner violence?
That's correct.
Okay. But would that testing help to determine if she had a change in functioning from that trauma of the intimate partner violence?
Absolutely.
And did you determine that she did suffer from a trauma as a result of intimate partner violence?
That was my conclusion. Yes, that's my opinion.
Now, in considering all the available information, you don't just rely on what Ms. Boone tells you to
No.
make your decisions.
No, I don't. I do interview a person as part of the clinical forensic interview, of course, but I also consider things that are reported, like in their arrest narrative, witness statements, all of the medical records. So there are a variety of sources of information, collecting data points and reviewing those to arrive at a conclusion.
So you did review Ms. Boone's previous diagnoses in her history?
Yes,
Did you consider the previous diagnoses in arriving at your own?
I did. Yes.
I want to
What
clarify
did
something here.
Miss
Did Brian
Boone-
testify about any intimate partner violence on the stand in front of this jury, Zoe? Just genuine question. I don't think that he did, because I don't think he was allowed to talk about it until Sarah opened the door and was allowed to use battered spouse. So they may call him back on rebuttal. And so you may be privy to some information that the jury does not yet have, is what I'm thinking, but he did not testify to that in front of this jury yet.
What had she been diagnosed with prior to you getting involved?
Section 704 conduct.
Roach.
Right. I'm a little bit behind here, I think. Oh, look at us on real time. I think this is going to be the last witness of the day. I think. Mama Shea, thanks for the 20 and for tuning in. Anyone else think this doctor is a mini version of Dr. Shannon in the Depp trial? Barbara says, I love this judge. Very fair to both sides. Thank you, Barbara. And also for your super sticker. Hello, Tanny. Life is filled with difficulties, so I try to see most things through a prism of grace. In this case, I can't get past the phone videos. Unintentional or not, she's responsible for the death of George. Thank you, Tanny, for tuning in, for your super chat. I'm glad I'm not on the jury. I think there's so many differing opinions in this chat. She's charged with second-degree murder, which requires a depraved heart. She's already been in jail for almost 5 years. She'll get credit for time served. She turned down a plea deal of 15 years, which means she probably would have had to serve another 7. It's going to be interesting to see what happens.
But you would agree, and I think this is a fair question, you would consider prior other experts who may have diagnosed her with something.
So I would definitely consider her mental health records, diagnoses previous clinicians may have arrived at the time
Okay.
when I diagnosed her myself.
Okay, and given the assessment that you did with Sarah Boone, and considering the totality and the time you spent with her and the other records, did you diagnose Sarah Boone with anything?
Yes, so post-traumatic stress disorder. It's my opinion at the time of the offense, she had depression and she had an alcohol use disorder.
All right. I know we've talked about post-traumatic stress disorder. I don't know if I need to ask you anything further. I think the jury probably understands that. Is there anything else you wanted to add about that disorder?
I mean,
I'm not sure what the jury's already been told about post-traumatic stress disorder, but in Sarah Boone's case specifically, because of enduring, she specifically noted the time that she was stabbed with the knife as being an extremely...
Sustained.
You have viewed Have you viewed some exhibits involving her being stabbed?
I think that we have had exhibits in common. I'm not sure what was admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
Right, you're saying?
Overruled.
that's not hearsay. If she saw the scar,
Just generally.
the
without
scar
getting
didn't talk to
specific.
her. The scar
I think
didn't
I've
talk
explained
like the crime scenes were speaking to the trooper Paul in the Karen Reed case.
post-traumatic stress, but if there's something else the jury you believe the jury needs to know, but it's a sort of trauma that occurs as a result of one or more events.
Post-traumatic stress disorder is the psychological after effect of being exposed to a very significant stressor or cumulative stressors that make the person's behavior, thinking, and mood change. And so the change can include things like the person becomes hypervigilant, is easily startled, has trouble thinking, has trouble sleeping. So their body is in a state of agitation. It can also include changes in mood that would include irritability, difficulty relating to others, and that they might be resistant to trust easily. So those are all
They
features.
have trouble sleeping sometimes.
Yes.
Sleep deprivation is a real issue.
It's associated with things like nightmares and having trouble settling.
Now, you mentioned that you had diagnosed her with depression. Can you just give us a general understanding of the jury of depression?
So the persistent sad mood, including feelings of hopelessness, helplessness, having difficulty concentrating, sleep problems, changes in appetite, those would be typical of depression.
And Sarah Boone suffered from that?
Near the time of the offense, yes.
All right, can you explain to the jury alcohol use disorder? That's a fairly new name. That's 5 or 6 years ago. The manual came up with a different name.
It did, right. And so that would be, in layman's terms, you might call that alcoholism. It's a tendency to drink too much and then have some kind of consequence in your life as a result of your substance use.
And alcoholism can be depending on how much you drink and then how often you drink.
That's right.
All that is something that you would consider in diagnosing.
Yes.
The many people who suffer from alcohol use disorder, I don't know how to put this, are they in denial?
I would say that is one of the stages of alcohol use disorder and amenability to treatment. So in denial, it's because you do not want to acknowledge that there are consequences from your use, because in doing that, you might have to reduce how much you're using. So to deny means that you feel that you can continue your use without having to change that. So you want to maintain the access to the substance.
You don't have a problem.
That's right.
Yep.
What is the difference between traits and a diagnosis?
Well, we all have personalities. And so you're going to have coping mechanisms that include personality styles. So for instance, even though you might not be diagnosable as something, there are times when if you're upset, hurt, frustrated, you have a mood state that's unpleasant, you're going to deal with that by using some kind of coping mechanism. So traits of personality disorders might be present in the way that you deal with inner pain, things that you don't like feeling. So some people, for instance, if they feel uncomfortable, they may cling too much or become excessively bonded to try to escape a feeling that they don't like. And that might be a dependent personality trait. It doesn't necessarily mean that they have a personality disorder, because that would have to be pervasive across all the environments. But when stressed or upset or not feeling good, you're going to use some kind of coping mechanism, and that might be one of the criterion, for instance, of the personality disorder. You would call that a trait.
And is it your understanding that this trauma that one suffers from repeat domestic violence can cause one to be considered suffering from the syndrome, we call it battered spouse or battered woman syndrome?
Yes. So the diagnosable condition would be PTSD or post-traumatic stress disorder. That's how a clinician would label the response to trauma. The pattern between partners, the person's coping mechanism because of that trauma, that would be what's considered battered spouse or battered partner syndrome.
And you're aware that concept of being traumatized by the battered spouse syndrome or the post-traumatic stress is relevant to a self-defense case.
Yes.
In a criminal context.
Yes, I understand that.
Could you tell us a little bit about that?
Well, under the battered spouse syndrome, the person would experience a trauma or a situation in which they feared harm. And based on that fear of harm, they would react in a certain way that might not be understandable to other people. So their fear is based on the pattern of behavior between them and their partner. That might not be the case for another set of people.
Now, I know that Dr. Lenore Walker is the one who first uncovered this syndrome back in the 70s?
Her research study generated the term. She was interested in why battered women specifically at first, that was what was studied, didn't leave their partner because of course they're experiencing traumatic events, risks to their life, but then they didn't leave. So she undertook the original research study on that.
And just briefly touch on, because I know Dr. Brandon has this, there was a 3 stages that Dr. Walker developed for that syndrome.
I think you're referring to phases that a person may go through, or the cycle of the relationship. That includes the tension building phase, in which there is the first instance that tension is building within the partner. There might be a change in tone, a signaling that there's a difference in agitation. The second is the true battering event. So something has happened between the partners that's violent in nature. And then third, there's the honeymoon phase, which is to keep the relationship intact. The batterer would engage in what's like called honeymoon behaviors, like trying to repair the relationship, apologize, essentially keep the victim from departing from the relationship. So those are 3 phases.
And is it fair to say that psychologically the abuser, does alcohol often involved in the abuse?
Yes.
And as far as the victim is getting abused, and you say it's a cycle, is the victim, when they go through that last stage, the honeymoon stage, are they thinking, okay, it's going to be better?
Yes, the hopefulness in that, trying to believe that the behavior has changed, that they're not going to be abused again, the hopefulness to maintain the relationship, to forgive. That's part of that last stage, phase 3, is maintaining the relationship.
Nicole Albert, Sylvia. Nicole.
I've asked this. Why would someone who has been exposed to intimate partner violence perceive the likelihood of a new violent event about to appear? Why would they perceive the likelihood of that violence differently than, say, a normal person?
Well, it speaks to the pattern. So any relationship will have its own special pattern, that you have things that only your partner knows about you, or certain looks that you give that mean something, and you learn that over time. So over a period of incidents, basically, the victim begins to perceive cues that would signal impending danger. Those cues could be really subtle, just a change in tone, or some small behavior that might not mean much to another person, but it has preceded other violent acts. So for instance, if your husband decides that he is not going out that night, he might put on different clothes to stay home. And that could be a signal, like abuse and violence has occurred in his stay-at-home clothes. For instance, that might not mean much to another person because, again, it's specific to that dyad. Those 2 people know those patterns. So the victim may perceive a small or subtle change in their partner as a cue because they've become hypervigilant. The body knows when it's experienced a threat to itself, and it will take note. We record memories differently when we're at risk. So these subtle cues become very well memorized by somebody who's being victimized.
Now, on this, and battered spouse syndrome is a subset of post-traumatic stress disorder, which you diagnosed Sarah Boone with. When those personality changes occur and they persist after an individual has been exposed to this extreme stress, is that when the diagnosis occurs?
Congratulations, Sharon.
The changes would be as a result of the pattern. The person experiences a change, like in their sleeping, in their hypervigilance. That's when you can diagnose it. So you can have a trauma or an experience of, scary incident, but it doesn't mean that you will absolutely have post-traumatic stress disorder. You have to have those reactive symptoms that would suggest that it's present.
In your opinion, And I know you've gone over this event with Sarah Boone, this February 23rd, 2020 event. It is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
Then it's fair to say that because of the intimate partner and the prior violence, that you would have a heightened sense of when danger was about to occur,
Yes,
when a threat was about to occur,
yes,
a threat of danger.
that's right.
Now, I want to talk about placating.
I'll come back to this question,
A
Morgan.
victim placating an abuser. Are there predictive cues which an abuser may exhibit to a victim that result in a high level of anxiety arousal, in which the battered woman may attempt to reduce through several different means to delay the beating?
Like
Can you explain
puzzles,
that?
Yes. So
finger painting?
the phase of the relationship that starts with that tension building, that is a jumping off point potentially. So if you can stop the escalation, you might stay in phase one for a period of time. Phase one being that tension building phase and trying to reduce it and not allow it to escalate. So placating the abuser might include distraction. It could include substance use. It could include a change of scenery. There are a lot of things that a partner will learn to do so that they don't have the escalation into an abusive event, if possible. Doesn't always stop it.
If
Now,
there's
when
anyone
you-
in the chat who can give Welshie some advice, maybe call the DV hotline. My daughter's been going through domestic DV for years, or DV for years. No matter what I do or say, she won't leave him. It's heartbreaking being helpless. Chatters, any words of encouragement for Welshie?
Doing all of the data, all the reports, medical records, and whatever reports you considered, videotape that you may have watched, as it relates specifically to Sarah Boone, are her words her power?
Her words, I would say, are the weapon that she has.
Explain that to the jury.
In reviewing the available videos that I had to review,
She
you would
did.
see that when Ms. Boone is very stressed, when she's experiencing a high level of anxiety, she becomes short in her tone. You can hear that in her voice. There's a strain, sharper words come out. I think that is the way that she would try to respond to Mr. Torres. You can hear that sharpness in her voice when she's very stressed out.
Now, would you agree that victims may exhibit a range of behaviors when they're suffering from intimate partner violence?
Yes,
Self-isolation,
yes,
suicidal thoughts,
yes,
substance abuse,
yes,
and there are often physical signs of injury such as bruising,
that's correct.
chronic fatigue,
Yes,
learned helplessness.
yes.
Can you tell I know Dr. Brandon spoke on it, but could you tell us a little bit about that?
So learned helplessness is when you start to form the opinion that nothing's going to make any difference. It comes originally from an animal study in which dogs were shocked, and the research study indicated that even when dogs were given an opportunity to escape the environment in which they were being shocked, if they were shocked enough, they just stopped trying to escape. So even though they had an opportunity to do so, they did not do that. That's called learned helplessness. It's the idea or belief that what your actions are going to do are not going to make a difference. So don't try.
What are intrusive memories?
Intrusive memories are an element of post-traumatic stress disorder in which you don't want to be thinking of a traumatic event, but it intrudes on something else you're trying to do. Like maybe you're folding socks or something like that, just doing something mindless, and that's what takes over your thought process. It's not something that you're trying to think about. We could plan what we're thinking about, or sometimes if you're just having this intrusive experience, that's not what you were intending to think about at all.
Is that one of the conditions that someone may suffer when they have this syndrome of battered spouse?
Yes.
I know there can be triggers that bring on these memories. Am I correct?
That's correct.
Are there also symptoms of this syndrome where, like in the alcoholism, where you have denial that you're in the middle of this cycle?
Well, as part of the relationship, there's an element of pleasure. Like you have early on in the relationship something that binds you together. So you're remembering that, you're hoping for that, even though the repeated cycle is going through the phases 1, 2, and 3, you keep hoping for elements of that honeymoon phase, wishing that it was better. So it is like denial. You're imagining the way it used to be. You have a recollection of that person showing you positive behaviors, and you're hoping for that. I also think it is typical for victims to not reveal to other people that the abuse is going on. And it seems like denial. In other words, your coworkers ask you, like, are you okay? Did something happen to you? You're not likely to disclose that. That looks a lot like denial. It is a denial in public of some of the private issues that you're having in your relationship. And that's because it's embarrassing. It's revealing a loss of control to other people. It's revealing that things aren't perfect. You might even get feedback that you should leave your partner, and that's unwanted because you're already having that, concern in your own mind about it. And so, it seems like denial on the outside to hide it.
Would you agree many people who suffer from this, they're minimizing what is happening to them?
Yes.
And they're numbing their emotions to it.
Well, to stay present and keep that relationship, it's very difficult for a lot of people because they're experiencing physical and emotional harm. So they want to numb it, because numbing it means that you can keep that relatedness no matter how bad it's getting.
Does some people with this syndrome disassociate?
Objection. Relevance.
Approach.
Yeah, Ed Wallace said before, I highlighted this one. Do you think that, is it me, or does this defense attorney get away with a lot of leading questions that are not objected to? Yeah, it seems that way, especially when he was questioning Sarah. But I think that both sides knew, and the judge knew, that if he didn't do it that way, the testimony could have gone on for days. And originally she was supposed to testify in a narrative fashion and just get up there and tell her story. But at some point that changed without telling me, because my scroller said
Objection.
narrative.
Relevance is overruled.
But yeah.
Do you agree that battered women often develop the defense mechanism of being able to psychologically detach from their body during a traumatic experience?
Some people do experience that.
They'll be able to bring the videos with
I'm
them
just
into
gonna
the jury
list some
room,
of the-
Sandra, so they will.
Symptoms that you find in battered spouse women, and just to see if you agree with these. We talked about intrusive memories and flashbacks of the past traumatic events. You agree with that?
Yes.
The severe anxiety and hypervigilance,
Yes.
the panic attacks,
That is sometimes present. It depends on how the person experiences anxiety, but some do have panic attacks.
very low self-esteem,
Yes.
poor body image,
Sometimes.
feeling that they have no control,
Yes.
sexual dysfunction,
It can be, particularly if the trauma includes sexualized attacks.
short-term memory problems and confusion,
Yes, that's part of PTSD sometimes.
and they can actually have physical health problems from the chronic stress and physical violence.
That's correct.
fear,
Yes,
constant fear.
that's correct.
Now, the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting.
Approach.
I'm like, not even paying attention to this trial anymore. I'm just watching you guys in the chat supporting each other and supporting Welshie, whose daughter is in a domestic DV relationship and she doesn't know how to help her. And you guys are amazing. You guys are amazing. Well done, chatters. Well done. To me, the most important part of this case is going to be the jury instructions. I mean, it's going to come down to the jury instructions. It's going to come down to the judge instructing the jury on the law. It's going to come down to whether or not these 6 people who are on the jury, because remember, in Florida, it's only a 6-person jury because this is not a capital murder case. There's no death penalty involved. They only get 6 jurors. So it's going to come down to what these 6 people believe. They're the finders of fact here. A lot of differing opinions in the chat. David, in my opinion, the defense is mischaracterizing her scar as a stab wound. It was a cut. Yeah. And also, David, I rewatched her testimony. Thanks for the 10 last night. And she didn't say that he stabbed her intentionally. He dropped the knife or something. The way she described it, it was not an intentional stabbing. I can't remember her exact words right now. Lisa, thanks for the 5. Sarah had the opportunity to get away. She had an obligation to do so before using deadly force. Depends on what the jury instruction is on battered spouse. The judge has decided to allow it. That's why all this stuff is coming in. So it's going to be interesting to see. We don't have... Florida is one state that has battered spouse. A lot of other states don't. I don't know if you guys followed the case of Marsha Thompson. She also was in Florida. She also claimed battered spouse. She killed her husband while he was sleeping on the couch. And she was acquitted by a Florida jury who said that all of the years leading up to the abuse was enough for her to be able to kill him while he was sleeping on the couch. So, juries can be, I have no idea what the jury's going to do. Chantal says the poll you take at the end of the trial is going to be super interesting.
You may
This is
proceed,
the most divided I've ever seen this chat, and I've been here for every single trial. I agree, Chantal. Thank you for your super chat.
Part, I'm asking about common things that occur by the abusive partner towards the victim that create this intimate partner violence or create this syndrome in the woman. Hitting,
Yes, that could be an overt act.
kicking,
Yes,
punching,
yes,
choking,
yes,
burning,
yes,
using weapons to hurt you,
yes,
a knife,
correct.
curtain rod,
Yes,
threatening to hurt you, your children, or your pets,
yes,
Ashley Benefield.
belittling and humiliating you,
that's correct.
taking your car keys,
That would be considered a form of control. So yes,
controlling your money,
yes,
control where you go and who you see
correct.
and who you can talk to,
That's right.
force you to have sex when you don't want to,
Yes,
stalking you,
yes,
Well done, Aaron Nash.
slapping you,
correct.
Stalking. All this is Ashley Benefield. Aaron's going to make a beer, 6 packs only, called Florida Jury. Well done. Jury instructions.
you victims that suffer from this abuse experience feelings of anger,
Yes, that can be in some of the phases. So
sadness,
yes,
hopelessness,
yes,
worthlessness,
correct.
intense feelings of fear.
Yes,
I would not advise calling
Abusers
CPS
have a tendency to have low self-esteem themselves.
because that could open up a whole other can of worms, KPT. Like real anger, like real bad. I would not advise that. I'm just going to delete it.
Overruled.
Abusers.
Overruled.
The abuser can have low self-esteem himself,
yes,
have a desire for power and control,
correct.
have a tendency to use alcohol or drugs.
Yes,
Abusers oftentimes have temper,
That's correct.
become jealous easily,
Yes,
very possessive.
can be.
This is not cross, David. We're still on direct. He's lollygagging me to sleep right now. Got to be honest. And I took a little nap during the break, so. I mean, she's a good witness. It's just not that compelling. I don't know what it is. It's just maybe losing them. They may be fidgeting. I want to know if they're taking notes. I mean, she did examine Sarah at
The victims can
least.
suffer from severe psychological distress.
That's correct.
Got with her 9
Is
times.
that what Sarah Boone suffered from?
Yes.
Too soon? Max Bang 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 is in the chat.
Dr. Harper, I'm showing you Exhibit 14, this is 5 photographs. Did you watch the video of the TV, the Battered TV?
I did.
You considered that in your analysis and your diagnosis?
Yes, I did.
And I'm going to show you some pictures. Exhibit 12. I believe she's testified this is where the curve line. Are you familiar with that?
Yes.
Exhibit 11, are you familiar with this photograph over here?
Yes.
Exhibit 10, which is the arm. Are you familiar with that photograph?
Yes.
Exhibit 9, picture of the bloody knee. Exhibit 8, picture of her black eye.
Yes. I've seen these.
Picture, exhibit 7, picture of her Sarah's lips and it's like an eyebrow.
Yes.
And this is a composite exhibit 6, which is of the stab to the leg. Are you familiar with those?
Yes.
And I don't know if you've seen this exhibit 5, is where she spilled some soup as a result of his behavior.
I'm not sure if I've seen this photo, but I've seen a medical record associated with that.
Of that burn.
Yes.
Exhibit 4,
Yes.
stay with that. Looks like exhibit 3. She was slapped on the tongue.
Yes.
2, which is bruising in his boot.
Yes.
Did you consider all those photographs informing your opinions that you've expressed here today as it relates to Sarah Boone?
Yes. Under the substantiation that she has indeed experienced past instances of intimate partner violence against her.
Is it fair to say that it takes time, a number of times, to visit with someone like this to build trust?
Yes, traumatized people are slow to disclose information. You have to build rapport. You have to make sure that they experience you discussing other things without an emotional reaction. They feel easily judged, as we mentioned, have defensive denial, things like that. So you need to build good rapport in doing an assessment with somebody that's experienced trauma.
So a lot of times they're very slow to open up and tell you about the abuse.
That is correct.
And they'll actually often lie about it.
Deny it, yes, and just say that that's not the issue or they're fine. So oftentimes I'll have an evaluation request come from an attorney who's having difficulty interacting with their client, and then ultimately it's a result of trauma.
Now, I know that you viewed everything and I know you've seen her 9 times. Is there any Did you feel like you had enough time? Was 9 visits enough time for you to feel like you had enough time and information to form the opinions that you've expressed here today and give it to this group?
Yes.
That's all the questions I have.
Okay, Cross.
Any cross-examination?
Yes, sir. Good afternoon, Dr. Harper.
Good afternoon.
So you have done some evaluation work on battered spouse syndrome for a prosecution in the past?
No.
All right.
She's
Have
never
you done
testified for the
insanity
prosecution?
evaluations for the prosecution in the past?
I have been called to testify about that.
So you understand when the government obtains a court order for their expert to come in and do an evaluation, it's for one evaluation, correct?
I believe that you're saying that the government can retain their own expert. Yes.
No, man, what I'm talking about is you just went through that you had 9 visits with Ms. Boone,
I
correct?
did. Yes.
And that was over the course of 8 different days because 2 of those visits were morning and afternoon sessions, correct?
That's right.
And what we are trying to help you have the jury understand is that when you get hired by the government and the court gives you an order to go evaluate somebody, you get one crack at the apple. Is that your understanding from your past work working for the government?
No, that's not always correct. There are many instances in competency evaluations where evaluators will request additional visits if they cannot determine their opinion on the first visit.
All right. Specifically, when it comes to an affirmative defense, such as battered spouse evidence and insanity, what is your understanding and your expertise?
What is my understanding of the
One.
issue? Oh,
Judge, the question.
Legal objection.
Objection?
Legal
Yeah, I
grounds.
mean,
He asked a question about battered spouse and
Approach.
insanity.
is he trying to say that is the state paying?
All right.
And
It
he's trying to
requires-
say you saw her too many times? What's he getting at here?
Court order for the state to go out and in battered spouse syndrome being used for self-defense, or affirmative defense such as battered spouse syndrome being used for self-defense, or not and insanity. It requires a court order for the state to go have an evaluator go, right?
yes.
All right. Now, what are the agreed upon criteria for battered spouse syndrome?
Well, you would evaluate.
Controlling who you go see. who you
Sometimes
hang
it
out
jumps ahead. Hold on a second. It's not me, it's them.
for battered. Now, what are the agreed upon criteria for battered spouse syndrome?
Well, you would
Not in the DSM.
evaluate if the person is indeed suffering from a behavioral response like a mental disorder. So first of all, has the person demonstrated that they've got a behavioral change? And is it in response to a violent act? Do they perceive threat where they've been exposed in the past? So pattern of violence that has repeated.
Does control over another person in an intimate relationship have anything to do with it?
Yes, it can.
Does isolation have anything to do with it?
Yes.
And by control, I mean controlling who you go see, who you hang out with, so on and so forth.
Yes.
And could it involve controlling personal items of the other person as well?
Yes, it can.
So that's what I'm asking. Like in the DSM-5 TR, I believe you pulled up narcissistic personality disorder.
Yes.
And so when you do that, it pulls up and it says there's 9 criteria and 5 of those criteria must be met to make a diagnosis for narcissistic personality disorder, correct?
That's right.
Now, battered spouse syndrome is not recognized by the DSM-5 TR, correct?
No, it's not a diagnosis. You wouldn't use it as a diagnosis.
Defense.
And what I'm asking is, even though we haven't written it down in the Diagnostic Statistical Manual, and I mean the like the Ohio State University or something, is it written down anywhere?
Okay, what? I mean, the DSM, like as in the Ohio State University or something? Did she say that she went to the Ohio State University, or is that just a reference that nobody's going to get? An attempt at snark.
Can one psychologist state, the Diagnostic Statistical Manual, and I mean the like the Ohio State University or something, is it written down anywhere? Can one psychologist or psychiatrist rely upon a recipe or a list of criteria that everyone else would be using in your field as well?
There is no standardized approach you must follow. In other words, sometimes if we have a statute, for instance, it would identify what we must investigate. It doesn't exist like that. There's no
not everybody knows
statute directing it.
And there's nothing written down anywhere that says, of these 9 criteria, these things must exist. Controlling your partner, isolating your partner, beating your partner, so on and so forth. Correct?
That's right.
All right. Now, this kind of abuse can come in the form of emotional or mental abuse outside completely of physical or sexual abuse, correct?
So that is a component. You can have extreme mental abuse occur of a person, yes.
And if that person responds to that environmental stimuli of whatever it is the partner is saying or doing to them, they may internally view that as traumatic.
They could.
Or they may not.
That's right.
It's entirely possible for 2 people to be in a 3.5-year relationship that has physical violence and neither one of them feel traumatized by that. Is that correct?
That's right. If they have enough supportive or positive experiences that would negate that ratio, so of positive to negative, they may feel okay.
And a man can be subjected to this sort of trauma, whether it be physical, emotional, or sexual by an intimate partner as well, correct?
That's right.
And it's basically it's unique to each relationship, right?
That is right.
But trauma is in the eye of the beholder. Is that fair? Whether a negative experience traumatizes somebody is going to be in the eye of the person who experienced that stimuli, correct?
I only partially agree with you. It's a complicated answer because some of the manifestations of trauma are behavioral. So for instance, when I evaluate veterans who have returned and they may not know that they've been traumatized, their bodily responses that include like difficulty concentrating, they can't sleep, they're hypervigilant. The PTSD diagnosis encompasses outward manifestations. So even though they don't acknowledge trauma, you can still identify it as a clinician.
But still, somebody like a homicide detective or a homicide prosecutor can go to scenes where there are dead bodies, go to autopsies where there are dead bodies, and not walk away with any trauma, correct? Whereas somebody else might.
Right. The environmental, I guess, cues for that person, and also working with law enforcement, they become seasoned to micro traumas. So the first, almost every police officer can remember the first dead body they've seen. So it's in their memory. And then they become accustomed to seeing gruesome scenes. They have an increased tolerance over time because it's part of their job. It may not be part of their intimate relationship that they have with someone else.
Now, you brought up veterans. Is something common with PTSD with veterans, something like firecrackers may set them off because it reminds them of acts of war?
That's right.
You're not suggesting to the jury today that if somebody who returns with PTSD from service and hears firecrackers is justified in going outside and just shooting bullets everywhere, correct?
No, that's not what I said.
I'm not saying you did.
Okay.
What this battered spouse syndrome evidence is helpful for is not that subjective mindset, but rather helping to explain the objective circumstances that are presented to somebody and how it might be different from somebody with those experiences. They may view something objectively different.
I partially disagree with your question because I would say that there are incidents or actual events between partners that would be a factual thing, something has happened. And then the person subjectively experiences that as, intrusive or controlling or traumatic. So that is the person's felt or subjective experience. The objective part is what happened.
But
A lot of
again,
questions about
as a
lesser
forensic
included,
psychologist-
or if it's just straight up murder too. We'll know more tomorrow when the charge conference is, what's on the verdict slip. Typically, manslaughter would be a lesser included of murder too, or it could be an additional charge. We're going to see tomorrow.
You're familiar with the justified use of force instruction, correct?
I'm not a lawyer though, so I'm aware of it, but I cannot debate fine points of that with you. I'm sorry.
I'm just helping, I'm trying to understand what you said before, because there's a subjective component, whether or not a person believes subjectively that they need to use some sort of force, deadly or non-deadly. You agree with that, correct?
I do.
And then there's also a second component that it's objectively reasonable to the ordinary person to use force, correct?
I understand what you're saying, yes.
And what I believe I heard you mention earlier about battered spouse syndrome was originally was meant to help understand why people stay in these relationships.
Originally, yes.
Because it may not just be intuitive to somebody who doesn't understand these things, why somebody who is abused time and time and time again would remain in that relationship, correct?
That's right.
And again, and I know you're not a lawyer, but if the law has evolved about retreat and not having to retreat and so on and so forth, that kind of changes some of the lens of this, correct?
Judge, I'm going to object.
Approach.
Another objection.
Check. Question withdrawn. May proceed.
All right. So you would agree that hypothetically, if somebody is running down their partner, saying negative things about them, telling them they're unattractive, telling them things that would potentially hurt their feelings, that could be an element of control of a verbally abusive relationship.
It could.
Okay. Propping one up, hypothetically saying, I'm the best thing that has ever happened to you, you'll never do better than me. Is that a potential component of the control that one in an abusive relationship might exert over an intimate partner?
Yes, to try to not encourage their partner to leave them. Yeah.
Considering gifts, hypothetically, that one partner has given to another partner, but considering it still to be your property because you gave it to them, is that a form of potential exertion of control over an intimate partner when you give somebody hypothetically a bike, but still consider it your own bike?
I mean, I don't think that's strong evidence of that. I think that it does happen in relationships and people do that in general, but I wouldn't say that's like really specific to this.
How about hypothetically exerting control over your intimate partner's identification papers, such as a birth certificate?
So that can happen. People will hide things that are required for work. For instance, like your driver's license or things like that.
Now I'm asking yes or no questions. If Mr. Owens would like you to elaborate further, he's going to have that opportunity in a little bit. Okay.
I don't know. He doesn't have to.
Hypothetically, if one partner destroys another partner's belongings, is that a potential example of exerting control in a relationship?
Yes.
Thank you. Hypothetically, is threatening to or actually using legal process as a threat against your intimate partner in a potential indicia of controlling your partner? For instance, X, Y, or Z, or I'm going to get you arrested.
Yes, I would agree that happens.
Yeah, he's describing what Sarah did. Exactly.
Now,
Okay, let's just settle the chat
I
for a
assume you
second.
would
Okay.
agree
She's
that
charged only right now, only with second-degree murder. Only. Lesser included may be something that is negotiated between the attorneys when they have the charging conference. But right now, she's only charged with second-degree murder. Sometimes, depending on how the trial goes, the prosecution may say, all right, you know what, we're gonna try for manslaughter or something lesser, and then it will be on the verdict slip. It's going to depend. Oftentimes, it is argued at charge conference, like somebody just said, and I put the comment up.
this cycle of violence that we've described, the tension building, the blow up, and then the honeymoon phase. You would agree that just one of those cycles could be enough to give somebody a traumatic experience if they took it as a traumatic experience.
Yes.
The defendant described her first date with Mr. Torres to you, did she not?
She did.
And at the time of this first date, they had obviously just met that night at a bar, correct?
Right.
They were not financially intertwined, correct?
That's right.
They shared no children in common.
That's right.
They did not live together.
Correct.
And after this description that she provided you, which included him smashing her phone, correct?
Yes.
Hitting her, first time she'd ever been hit in her life, correct?
Yes.
And making her crouch in like a fetal position on the porch for several hours to the point where it hurt her back, correct?
Yes.
Threatened to sodomize her,
Correct.
and she described that she was all bruised up, correct?
Yes.
After that, this is the first time she had ever met him, correct?
I believe so. Yes.
There was a second date, correct?
Yes.
Despite not having any of that intertwinement that we went through prior to this description, correct?
That's right.
Now, it is possible under what we've discussed, right? Just that quick one date can be that buildup of tension and blow up, correct?
Yes.
But it's different hypothetically than saying a spouse who is financially dependent on
I don't like
his or her other
hypotheticals.
spouse in a 20-year marriage with a house full of kids than a first date, correct? You would agree in severity, in the intertwinement, there's a difference.
There's a difference in intertwinement. The pattern can be exactly the same.
Good answer.
Now, of course, there are many different reasons why somebody will stay in a relationship that, when perceived from the outside, others would say is abusive, correct?
That's right.
The defendant described that she felt like she was making Mr. Torres a better person, correct?
That's right.
A better father,
Yeah.
correct?
Right.
A better ex-husband.
With phone calls. Yes.
And she would tell him to call his children,
That's right.
make sure that he sent them Christmas gifts,
Yes.
and make sure he sent his ex-wife money when she asked, correct?
Yes.
So you would agree those are indicia, or indicators, sorry.
Understand?
I know you mean, that perhaps she wasn't necessarily financially dependent on Mr. Torres, correct? I'm not saying conclusion, but those are indicators. If you're saying, please spend your money elsewhere, that I don't need your money, correct?
No, because even if there was money that was needed by Ms. Boone, her tendency to put the needs of her partner before her would direct her to do exactly that, like make him better, make him have the availability to visit his children, send them presents, even if she's the one that needed the money.
And in her perspective, Mr. Torres needed her to do this to make him a better person, correct?
I believe that, yes.
How many years of her adult life did she describe working?
I don't think she gave it a specific quantity. We just went through a variety of her jobs that she had in the past.
And, you know, she was low 40s when she met you 4
Yes.
years ago?
That's right.
Low 40s, early 40s?
She had been 18.
Low
for
40s is a
probably about
temperature.
24 years. Did she give you a 24, right? 24 plus 18, 42?
You said for 24 years, and that's why I was confused. You can't be 18 for 24 years, but
Did
24 years ago, I would agree.
her work history kind of flesh out to be 24 years is what I'm asking?
I'm not certain.
And at the time, in the apartment in 2020, she had not been working, correct?
That's right.
And had not been working for some time.
That's right.
And what she was doing was living off of the settlement that she had been bought out of with her husband, was lump sum plus $1,000 a month in alimony and $100 a month in child support, correct?
Yes.
It was Mr. Torres who would work, correct?
He worked at Ace Hardware, I think.
When he would show up.
Right.
Sometimes he didn't show up, is what she indicated, correct?
Yes.
Because of his drinking problems.
Yes.
Did she describe to you, well, let me strike that. She did describe to you one instance at least where violence occurred in front of her child, correct?
Yes.
And that her child had gone to school and reported it, correct?
Yes.
And you understand as a forensic psychologist that teachers are mandatory reporters, correct?
That's right.
Did you review any DCF records in this case?
No, I didn't receive any DCF records.
Did Ms. Boone ever indicate to you at any point in time she became too afraid to let Lucas come over to the house?
Yes, there were times where she would ask Mr. Boone, so Brian Boone, to not bring him there.
And Mr. Boone was aware.
She was too afraid to let her son come over to the house, prosecutor, and you think that's good for your case? What am I missing? That's not good for your case. It's good for the defense.
Of this because she would say things like that, correct?
Yes.
And at different times, she told you that she would go over to Mr. Boone's house to escape the violence of Mr. Torres.
That's right.
And February 24th of 2020, the child was scheduled to be picked up by Miss Boone, correct?
That's right.
Despite everything that she was aware of and what Mr. Brian Boone was aware of, correct?
Right.
Is he saying that she should have left? Is the prosecutor's argument now going to be like, she should have left? Okay. Yeah, I don't know. This is weird.
And you saw in her police interview that she swore on the life of her son that she was telling them the truth, correct?
Yes.
Yes?
Object.
Approach.
Yeah, I don't know. I don't get what he's doing either, unless DCFS did not find anything. She's just lying to the doctor. But remember, DCFS doesn't always find stuff. I don't know.
His life that
None of these
Or
records
phrase it.
have come in.
she swore on her son's life that it was not intentional that she ended up killing Mr. Torres, correct?
That
I object.
She swore that it was not intentional that she killed Mr. Torres. Hi, Out of Scope. Thanks for becoming a member. Chickens to Crochet. Thanks for the 20. As a former paramedic, I can promise you that seeing unalive bodies and other really horrible scenes never leaves you. Crocheting is my self-care to deal with my PTSD. This cross is kind of irking me. Crocheting faster. Welcome to the Rage Crochet Club. Inside chat.
Objection sustained. Question is stricken. Members of the jury, questions are not evidence, and you're not to give them any weight whatsoever. Mr. J, you may proceed.
She's quote unquote swore on her child's life that it was not intentional. That, correct?
before I answer, I'd like you to direct me to that part of her interview. So
I'll strike it with you.
Oh, he's okay. She swore on her child's life it was not intentional. It's going to be part of the jury instructions. That's going to be part of battered spouse syndrome jury instructions. That it was an intentional act designed in self-defense, and because she was in imminent fear of her life, and they're going to try and say she swore on her son's life that it was not intentional. Therefore, you can't find battered spouse. That's going to be their argument.
Predated her relationship with Mr. Torres, correct?
yes,
And so when diagnoses predate a violent intimate partner relationship, there is an independent cause, even though they may then later contribute to the phenomenon, is that correct?
well, I wouldn't say that all mental disorders have an independent cause. Sometimes they're spontaneous or biological in nature.
Well, let's talk about hers. I mean, you're familiar with her prior diagnoses, and you went through her childhood, so on and so forth, correct?
I did.
So she was bringing some things with her prior to Mr. Torres' relationship, correct?
She had these.
All three
She did say it, yeah,
Yes, she
many
did.
times.
Thank you.
She said unintentional many times. She said, I swear on my son's life once.
You reviewed some Advent health records, correct, of hers?
Yes,
And some Aspire records of hers, correct?
yes,
And you would agree that there are times in the Advent health records where she goes to the hospital and then leaves before getting treated, correct?
yes,
And there is a time when she goes to the hospital where she is described, their words, not mine, as having ETOH on board.
yes.
Do you understand what ETOH means?
In a medical record, you would use that shorthand for alcohol.
Or ethanol, right?
Yes,
Drinking alcohol, not the other stuff.
correct.
And in the records that you reviewed from Aspire, she came with complaints of depression in January of 2018, correct?
That's right.
And ethanol or alcohol is a central nervous system depressant, correct?
Yes.
And I know you're a psychologist, not a psychiatrist. So let me know if I'm pushing you too far and you're not going to answer.
Okay, that was
But
a
you
little
are familiar
rude.
generally with the effects.
Okay, I don't know. I don't know. First of all, I know you're a psychologist and not a psychiatrist. So let me know if I'm pushing you a little too far. I mean, he's nothing compared to the Ashley Benefield prosecutors, the evil stepsisters, but he wasn't this rude to Sarah Boone, right? She's an expert witness. She's a doctor, sir. I mean, I know you're mad because she got in at midnight last night and maybe you couldn't do your deposition or maybe they did it during lunch. Like, I don't know, but that was a dig. And we're sitting at home and we're offended by this. Maybe some of us who are women, who are women professionals, who have law degrees and are doctors, but let me know if I'm pushing you a little too far. Okay. This might turn the jury off right now. Do you know what ETOH is in a hospital record? Okay.
She came with complaints of depression in
I rewound
January
it.
of 2018, correct?
That's right.
And ethanol or
It's not
alcohol is a
necessary.
central nervous system depressant, correct?
It's just not
Yes.
necessary.
And I know you're a psychologist, not a psychiatrist. So let me know if I'm pushing you too far and you're not going to answer. But you are familiar generally with the effects ethanol has on the body.
Generally, yes,
And you diagnoses of alcohol abuse disorder.
I do.
And in your professional life or personal life, are you familiar with the standard serving size of drinks when you're evaluating somebody's drinking? For instance, hey, I only drink 2 drinks a day. All right, well, are they 64-ounce mugs of beer or are they 12-ounce? So are you familiar in that context?
It might be a question I would ask during evaluation. What are you referring to? Is it a mixed drink? Is it a shot? Like, I try to identify that.
And do you ever ask if somebody says they drink 2 glasses of wine, well, how big are the glasses of wine?
Sometimes.
And is your understanding that 5 ounces is the standard serving of wine since it's about 12% alcohol?
I'm not sure what the standard size is, but I would ask regarding like a wine glass.
And in January of 2018, when she came in crying and complaining of symptoms consistent with depression, she had a blood alcohol level of 0.165, correct?
I believe so.
And in October of 2018, when she ended up going to Aspire, when she was found stumbling by police, she had a breath alcohol of 0.185.
I'm reacting to your description of her stumbling by police. I know she approached police for help. So
Yeah, but Terry, he wasn't asking about drugs. He was asking about, do you know what ETOH is? I think, right, she saw her 9 times. It wasn't like she saw her for 3 hours and just made a diagnosis. I don't know.
So there have been 2 sets of records, but I believe you may have the same set that I received on September 27th of 24. Can you turn to page 21 of 57 of the Aspire records?
Rubber Tucky number 28.
mine aren't numbered,
May turn off the
but
jury.
I will.
May I approach the witness?
Yes.
Kind of like telling a chiropractor that they aren't a real doctor. Oh, I know what he meant. I just don't know if it's going to turn off, it may turn off part of the jury. I don't think he needs to, I think his demeanor can be different and he can still get his points across. But we've seen way, way, way far worse than this.
Page 2157 on records from Aspire that was provided to me by the defense on September 27th of 2024.
The way he said it.
And
So, let me know if I'm pushing you too hard.
The first to the 4th lines.
All right.
All right, Judge, I would ask that she be allowed to read that entire paragraph under the rule of completeness.
Approach.
Approach, 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 approach.
Thank you. 2018. All right. October of 2018, or of 2018, there was a second visit to Aspire, and That was based upon her being found stumbling by law enforcement with a .185, correct? And that's
She
supposed to
walked
be-
up. Okay. So I'd have to say no, the way you phrased the question.
Ma'am, Boone was stumbling due to her level of impairment, .185.
Yes, I would agree.
Is that part of the records you relied upon?
Yes.
And then he calls her ma'am instead of doctor. I don't know. Ma'am. We've seen so much worse. Crunchy Frog. Did you watch the Ashley Benefield trial? Just go one day for cross and watch.
When you talked to Ms. Boone about that, she kind of just described an event of June of 2018 and blurring those two events, did she not?
No, she told me she had 2 different Baker Acts.
Did she describe it as being June of 2018?
I'll have to reference my interview note to find that if you would like me to.
Yeah, rock on. Rock on, doctor, not ma'am.
Do you remember giving a deposition on October 1st at the state attorney's office downstairs?
I do.
Oh, they did do her
And,
deposition on October 1st.
At that point in time, and I'll ask opposing party, you want me to show her prior statement before I ask her about
I
it?
think she's got a deposition.
Do you have your transcript?
I do.
So a Baker Act is similar to what they call a section or section 12 in Massachusetts. It's a 72-hour hold. Can be voluntary or involuntary. So they're saying that she was Baker Acted twice.
So for the record, it's page 34 that I'm referring to. Line 16, 17.
Describing her experience. That's what I said in my deposition, that she was describing her experience in June of 18.
And she described this experience as going to the hospital to find a pastor, correct?
Yes.
And ends up going to what we call Lakeside then and Aspire now, right?
Yes.
And then what you described was she was talking about more of the violence that occurred specifically regarding a significant episode of Jorge driving her roughly in the car, so on and so forth, correct?
Yes.
All right. Those were 2 separate incidences. January when she came looking for the pastor, correct?
So I'm just clarifying that there's a record that we started with this conversation from October of 2018. And there is a description of her trying to go to the hospital to seek a counselor. So those are 2 different instances.
In January of 2018, when she went to the hospital crying and signs of depression,
Bless you.
she indicated that was because her husband and son had gone out of town and she was feeling lonely and sad about having lost her job a few weeks earlier, right?
There were numerous stressors there, yes.
Nothing mentioned about any problems with somebody named Mr. Jorge or George Torres, correct?
You're talking about January?
Yes, ma'am.
I think both things can be true. I think she could be a victim of DV, and I think she could also be an abuser, and I think she could have also done something with a depraved heart, and I think she could have also intended to kill him. Excuse me? ERP Thompson Queen, do you want to tell me how I should run my channel? I'm not talking over the testimony. I pause it. I talk. Seriously? I'm going to turn off the air conditioning.
So the hospital records are not referencing her relationship with George on the January date.
Now, in talking about February
Yeah.
23rd, 2020. with
Maybe you could try going to a
Talk
channel
with-
where they just play the feed and they don't even come on screen, or people who never show their face on the screen. It's just so rude.
About that on several occasions, correct?
I did.
And part of one of those conversations, at least, was about an incident that she indicated had happened the night before February 23rd, 2020, correct?
Yes.
And she indicated and told you that she had been dragged down the stairs the night before the suitcase incident, correct?
That's right.
And in part of your review of this case, you reviewed all the crime scene photos, correct?
Yes.
And those include photographs of Miss Boone, correct?
Yes.
And were there any indications in the photographs of injuries on her consistent with being dragged down the stairs of carpet?
I didn't see inside her scalp. So I didn't see photos of inside, her hair follicles and this area of her head. On her outward body, there were no indications of that.
And did you ask her how it was that she was injured during this dragging down the stairs?
I don't think I went through specific injuries to her. No.
Do you agree that alcohol intoxication affects the credibility of a historian that's providing history to you, patient, or a client?
If they're actively intoxicated, yes.
We had talked, you and Mr. Owens, had talked about narcissistic personality disorder earlier.
Yes.
And that is a recognized diagnosis in the DSM-5-TR.
That's right.
And there's 9 of those, correct? 9 traits?
You're talking about the criterion of narcissistic personality disorder? Yes.
Like page 761 on your hard copy?
Thank you.
Thank you, Jessica.
All right.
Was I close? I have a digital copy.
760, but
Okay.
Thanks, Amy.
One of the criteria is has a grandiose sense of self-importance.
That was great. She gave him a look. He said grandiose, or he pronounced grandiose wrong, and she just looked at him funny because now she's going to get him back. Watch.
Was I close? I have a digital copy.
760, but
Okay. One of the criteria is has a grandiose sense of self-importance. For example, exaggerates achievements and talents, expects to be recognized as superior without commensurate achievements, correct?
yes.
2 is preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love, correct?
Yes.
3, belief that he or she is special and unique and can only be understood by or should associate with other special or high status people, or institutions, correct?
So 3, just caveat, it says believes, not belief, but the rest of what you said I agree with is the criterion.
4 requires excessive admiration.
Yes.
5 has a sense of entitlement, unreasonable expectations of especially favorable treatment or automatic compliance with his or her expectations, correct?
Yes.
6 is interpersonally exploitive, takes advantage of others to achieve his or her own ends, correct?
Is interpersonally exploitative. I agree.
7 lacks empathy, is unwilling to recognize or identify with the feelings and needs of others, correct?
Yes.
8 is often envious of others or believes that others are envious of him or her, correct?
Yes.
9 shows arrogant or haughty behaviors or attitudes.
Yes.
Is he gonna try and diagnose Sarah by checking off all the boxes on the list of things he just read, even though he's a lawyer and not a psychologist?
You believe that she has traits of that disorder, correct?
Yes.
Well done,
Grandiose
Leanne.
sense of self-importance.
There are indications that she feels like that or has expressed that before.
So that's a yes.
Yes.
Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love.
No.
Do you remember going to the state attorney's office on October 1st of 2024 and giving a deposition?
I do.
And it was in front of a court reporter, like Madam Court Reporter here.
Yes.
And you swore to tell the truth, the whole truth, nothing but the truth, correct?
Yes.
And referring to page 89, lines 18 through 20. Let me know when you're ready. Are you ready?
Yes.
Did you give the following answer to the following question? Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love? And your answer was yes?
I did answer yes there.
She does not, according, in your estimation, does not believe that she is special and unique and can only associate with high status people, correct?
No.
Does not require excessive admiration, correct?
Correct.
Does have a sense of entitlement,
Yes.
is not interpersonally exploitive,
Correct. It is not.
We will turn this car around right now, Carrie. We will. You know we will.
and when discussing whether or not she lacked empathy or was unwilling to recognize or identify with the feelings or needs of others, you indicated that that might be the case, but it's not intentional.
In other words, she's not aware she's inconveniencing others.
So there was 3 of those traits, correct?
Yes.
Not 5, which would be required, correct?
Right.
For a diagnosis of the personality disorder.
If that were the correct diagnosis, you would need 5.
All right. During your conversations with Ms. Boone, the defendant in this case, she explained to you that cheating to her means when Mr. Torres would look at pornography, correct?
Correct.
Not a real life woman, correct?
No, not that he was engaging in sexual intercourse with actual women.
Wait,
Part of the records.
with a real life woman? Is that what you just said? Hold on. In this case, she explained to you that cheating means looking at corn. We have to call it corn because AI program for YouTube does not like the P word.
Boone, the defendant in this case, she explained to you that cheating to her means when Mr. Torres would look at pornography, correct?
Correct.
Not a real life woman, correct?
No, not that he was engaging in sexual intercourse with actual women.
Part of the records that you did not review were the text messages that were part of the phone extraction of her phone device, correct?
That's right.
Corn
You
addiction.
indicated in your conversation with Mr. Owens that some of the traits that are commonly seen in abusers would be.
A lot of women feel that way. You're right, Crystal. A lot of women do. But not only that, he was also communicating with other women on his phone, right? He was on an app or something. Didn't really come in yet. It did. I mean, they asked Sarah about it. You know, who's Christine? Who's Crystal? Who's this one? Right?
Be control, jealousy, easily angered.
This could be, yes.
What other traits for just common for abusers?
Being a person who segregates their victim away from other sources of support, somebody that exhibits coercive control, meaning that they would prevent the person from engaging in activities that would be independent, so restricting their ability to have independent, like life, job, money, things like that, that would be supportive of them being left, for instance. Other things would be using emotional expressions like rage to cause a physiological reaction in another person. So those could be additional descriptions.
specifically the materials you reviewed. I just want to make sure we're on the same page. Paperwork from prior cases involving Mr. Torres and Ms. Boone.
Yes,
Medical records for Mr. Torres.
that's right.
The medical and Aspire records for Ms. Boone that we've discussed.
Yes,
The crime scene photos from the incident in February.
that's right.
Pages 1 through 413 in discovery in this case.
Right.
A photograph of a suitcase and 2 videos involving the suitcase,
That's right.
and additional videos on that phone, correct?
Yes,
Such as baseball bat smashing the TV.
that's part of it. Yes.
And then did you review any other videos where there's conversations between Ms. Boone and Mr. Torres?
Yes.
One prior 911 call?
Yes.
Now, today you had indicated that you had reviewed the photographs from some prior incidents of violence, correct?
Yes.
When is it that you did that? Was that recently?
No, there are photos included with the
The prior case packages?
case packages. Thank you. I'm not sure what to call it. So,
That's fine.
all right.
All right, and did you review any body worn camera from those prior case packages?
No, I did not. I didn't have that.
Anything else that you reviewed that I've not covered?
Are you speaking of documents only?
Yes, materials other than your 9 visits with the
All
Materials.
right. Just checking with the
That's fine.
folders I
I
prepared
just
for
wanna make
today. Investigative report. I don't know if, I guess that would be part of the discovery. The investigative report is within those 413 pages.
Did you interview anybody else personally besides Ms. Boone?
Yes.
Who else did you personally interview?
Melissa Sexton?
All right, anybody else?
No,
Who's Melissa
You
Sexton?
didn't interview Brian Boone, correct?
I did not.
You did not interview their child in common, correct?
No,
And you didn't review the phone text messages extracted from her device, correct?
no, I didn't.
Did you review any records from the jail?
No,
And, yes,
All right, what are we approaching for this time? Who's Melissa Sexton? Anybody know? Did I miss something? Thank you, St. Goddess, for becoming a new member. And Cindy, who says, you and your chat are the highlight of my day. Oh, Cindy, we love you. We love you, Cindy. There's a good question in here before that I highlighted. Lally's replacement. We're still waiting for you. Can you still claim marital privilege in court if divorced? You cannot testify to communications that happen during the marriage, even after you are divorced. You can testify as to observations, just not communications. Hope that makes sense. Who's Melissa? Oh, thanks, JD's in a foul mood, and he definitely helps. It wasn't as funny today as we usually are. It's been a rather, but I'm glad we're here for you, JD. We are here for you. Corn is also used by some women. That is true, Sonia. The property manager who also had a DV, she did not testify though, right? We heard from the male property manager. Zoe, yeah. Yes, yes, Sandra. Isn't it interesting how day one we were 100%, near 100% against Sarah. Day 4, we're all split. Right. It's so different. I mean, I think, I don't know if any of you who have been following this case like religiously since the very beginning, it's been almost 5 years, knew about all of these incidents that we saw pictures of and heard the deputies who responded to the calls. And, you know, I think a lot of people just thought it was a slam dunk guilty. I think the prosecutor thought that too. And I think he's less prepared than he probably should be because he just thought he was going to walk in here, phone it in, and it was going to be done. You know, that it was just going to be done. All right. I have to run for my usual 3:45 run. I will be right back. Do not fear. It is still on. It is still playing. I'll be listening and I will be right back.
The objection is sustained in part and overruled in part.
You testified earlier in the normal course of practice of forensic psychology and psychiatry, you all do rely upon the diagnoses of other experts, correct?
You can inform my opinion, yes.
And you have not reviewed any electronic communications in the form of text regarding Ms. Boone's case, correct?
No, I did not.
Or recorded phone calls of any type, correct?
Well, 911.
Other than that.
No, other than that.
Now, let's talk about the February 23rd, 2020. She told you that they didn't really have anything going on to do that particular day, correct?
Yes.
It was a Sunday, correct?
Yes.
Did some chores, and then as a reward, they could rest after doing those chores, correct?
Right.
She indicated to you that she and Mr. Torres did not begin drinking till about 4 p.m., correct?
I'll have to reference.
Page 36 of your deposition, if you care to use that.
Great, thank you. 36?
Yes, ma'am.
All right, I'm with you, around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5 liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February 23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
No.
And did she tell you that they had any wine left over from the day before that they consumed that day?
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then, as the receipt showed, there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Around 100 pounds.
And in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Torres was 103 pounds at his death?
Yes.
Do you take into account this alcohol consumption when evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Please silence your cell phone. You may proceed.
So she did not describe herself as intoxicated originally when we discussed this. So
So the answer is no. She did not describe herself as intoxicated.
intoxicated, right?
Hypothetically, if she had told the jury that she was intoxicated at the time of the offense, would that affect your evaluation of her credibility in the history she provided you?
No, because that was also my opinion.
Did she indicate to you in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
And what points in time were those?
So she did not remember taking the videos of the suitcase or the incident in the suitcase until she was at the interrogation room, I guess, and then they were going through them with her. Then she recalled that.
I'm talking about specifically with you. Did she indicate that there were any portions of the night or day or night that she did not remember?
I can't recall anything specifically right now.
Hypothetically, if she had indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with what she told you then?
No.
Well, she didn't indicate to you that she forgot any part of the night, right?
Right. She just didn't say that. So
Would it affect your evaluation of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes before the videos?
not really, no, because the event and the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory could hold that much unless they have like photographic memory or something.
I'm not asking about hours and hours, itemization of her day's events. We're talking about the 20 minutes of the offense. Does that affect the weight that you give her history she provided you? Just yes or no?
No.
Now, what she indicated to you was the day had been going well. It was fun and games, correct?
Yes.
Conflict-free?
To her, she said it was a good day. So
Okay.
that's what she told me.
She said it was a good day.
Yes.
And there comes a point in time where the activities turn toward hide and seek, correct?
Yes.
And she goes up to the shower?
Right.
And when she comes down from the shower, that's when Mr. Torres is in this suitcase, correct?
Getting into it.
And she goes over to the suitcase and zips it, correct?
Yes.
And did she describe whether it was 100% zipped to you or just a certain percentage?
She said that it wasn't zipped all the way.
And still then, that was funny to the two of them at first, correct?
That's right.
And then there came a point in time where Mr. Torres was getting mad about being zipped in the suitcase.
She told me that he was getting mad. Yes.
And that, in turn, made her mad.
That's right.
What Mr. Torres was saying was, I can't breathe, correct?
That is what's recorded on the video.
Well, I'm asking you about what you reported her saying.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying that was making her mad.
Well, what else was he saying?
She, at the time, she said that he said something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
You didn't find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important
Okay. Then explain. Why wouldn't you ask that question?
because as a person who is traumatized is describing their experience as a trained clinician, you will allow open-ended discussion of that experience. And so it's not an interrogation. You don't go asking confrontational questions at the time of their first narration.
Well, you had 9 visits with her. Did you follow up on your 9th visit?
I asked her different questions about
Did you ever ask
being
her?
confrontational.
Did you ever ask her specifically in any of your 9 visits with her what it was that he said that made her mad?
No,
She never described him doing anything to make her mad, but it was words, correct?
right.
And once she got mad, she decided that she was going to leave him in there for 2 minutes.
That's right.
Not 3, not 1, but 2, correct?
That's what she said.
And the reason she was doing that was because she wanted him to understand how it feels to be choked and what she had experienced.
That's right.
Did you ask her why she didn't let him out of the suitcase after 2 minutes?
Yes, I did actually ask her that.
And what did she say?
Well, she thought that he could get out himself. That's one thing. She said that when she was able to unzip it, it was not some significant thing. She was able to unzip it easily. So she said it never occurred to her that he couldn't get out.
You may proceed.
I heard the judge yell at someone about their cell phone while I was on my little journey, and my service didn't cut out at all. So I want to know how you guys are digesting this.
And you reviewed the still photograph of the suitcase as well as the 2.
Oh, hi, Emmy. This is Cross. This is the prosecutor. Thank you, Gina. This is the prosecutor crossing the defense witness, forensic psychologist who has seen or met with and evaluated Sarah Boone over 9 visits, which is more than we see in most expert witnesses who are testifying forensically as a psychologist or other doctor. 9 visits. And if you're ever confused, just look at what's scrolling on the bottom and it will tell you. I know it's very small font, but 'tis what it is.
videos.
Right.
And did you understand what the metadata or what the timestamps were for each of those items?
I'm sure when I reviewed it, I saw the timestamp. Yeah.
Would you agree that 20 minutes is 10 times as long as 2 minutes? And if Mr. Torres had not been able to get himself out of the suitcase within 20 minutes, she didn't indicate that she let him out, correct?
She did not.
She described to you, Ms. Boone being the she, that she was helpful to the police.
Yes.
Do you agree with that assessment that she was helpful to the police?
In the sense that she was having conversations with them without counsel, I would consider that helpful to the police.
Do you think lying to the police is helpful to the police's investigation?
No.
Do you agree that she was not truthful with them?
Yes, I think that I would agree with that.
And when she described getting Mr. Torres out of the suitcase, she described stretching his little legs.
Yes.
Stretching his
And
little
she
legs.
Stated to you there was no fight that day, correct?
That's right.
Just
Physical,
wanted him to be uncomfortable.
I need to clarify, physical fight.
Right.
Yes,
Just wanted him to be uncomfortable,
yes.
correct? And then there was a description of a bat and her using it to nudge, right?
Poke.
Poke. And so do we agree that that means like poking out like this as opposed to swinging it like your baseball hitter?
I would agree with you.
And you reviewed the autopsy report, correct?
I believe so.
Did you get an opportunity to review the autopsy photos?
Yes.
Did you question her when she said that she only poked him with the bat?
No.
Not in any of your 9 visits?
Did I question her about whether, can you just repeat the question? I want to make sure I'm answering it correctly.
Yes, ma'am.
Okay.
Did you ever, in considering the autopsy report and the autopsy photographs that you reviewed,
Yes.
when she said that she nudged or poked with the baseball bat, did you ever question her about that, given the severity of his injuries?
So to answer correctly, I did question her
What did she say?
about how she used the bat.
Okay.
And she reiterated that she poked and she gestured what she meant. So I did question her about that.
And did you have any questions about that history she relayed to you, given the other evidence in this case that you reviewed?
Just in contrast to the interrogation video. So that,
It didn't contrast to the autopsy photographs or report?
Judge, I object.
Approach.
Thank you, Barbara, who sent me 5 matcha lattes and says, in the last couple of days, you must need a lot of coffee. All the different cases that I'm covering, and she's enjoying it. Thank you, Barbara, so much.
You may proceed.
Did she indicate all this nudging or poking with the bat was done while he was inside the suitcase?
yes,
She never told you that there was any nudging or poking with the bat when he was outside the suitcase?
correct.
She indicated that she ended up flipping the suitcase over face down.
That's right.
Yeah, that's right, Victoria. Victoria says, our experiences are just that, our experiences. It's impossible to transpose what we might do onto another. Some survival strategies for victims of DV can also appear abusive. Right. Agreed. I mean, and I hear it both
Did she
ways. I
tell-
hear people say, I was a victim of DV and I had it so much worse and I never killed anyone. And other people who say, I was a victim and I absolutely believe her. I mean, and that's why the jury is so important here. That's why jury selection is so important. That's why it's so important that jurors are truthful on their questionnaires. That is why, in my opinion, that if juror 15 really did, well, we know that juror 15 in the Ashley Benefield case really did lie on her questionnaire. Whether or not that's going to be enough for the judge in that case to grant her a new trial remains to be seen. But that's why jury selection is so important. That's why truthful jurors are so important. That's why in some cases it's better to have a bench trial and let the judge decide, you know? And in a case like this in my mind right now is a crapshoot. This is like walk into a casino, take your 15-year plea deal and throw it onto the roulette wheel, throw it onto the roulette table and spin the wheel because you never, ever know what a jury's going to do. And you can't rely on it. You can't rely on your lawyer's advice saying, well, I really think you're going to be acquitted, or I really think there'll be a mistrial, or I really think, they'll only find you guilty of manslaughter and not second-degree murder. It is a crapshoot. Juries are a crapshoot. Never bet on what a jury's going to do. Did anyone think we were going to see a mistrial like Karen Reed? Did anybody think the jury was going to be hung there? I didn't. I thought that was going to be one of the fastest not guilty verdicts in that we've seen. But no, it was 40 days of deliberation and a hung jury, and we're going back for a retrial. So you just never know. Spin to win, right?
Tell you about Mr. Torres calling his brother earlier that evening?
No.
Did she ever give you a history about a loud boom occurring inside of her townhouse that evening?
No.
Yes, Carly was denied a new trial, but I think they're still going to appeal. And also, I want to tell you, for those of you who followed Carly Gregg with me, either one or both of her grandparents are going to be on the show with me. This is coming Saturday. I haven't posted it yet because I'm just waiting to confirm the time, with Bridget Todd at about, I think, 1 p.m. Eastern. So put it on your calendar. Make sure you have the bell set so you get all notifications, because I'm very interested to hear from Ashley's parents, Carly Gregg's maternal grandparents, who stood by Carly the entire time and still to this day.
Never had the opportunity, obviously, to interview Mr. Torres about these things, correct?
Of course not. No.
No other questions?
You didn't have the opportunity to
Any
interview
redirect,
Mr.
Tammy?
Torres, did you? Obviously not, no.
Nation. Yes, sir.
All right, this is redirect.
The state attorney talked to you about power and control, that an abusive partner will use power and control over the victim in a intimate partner violence situation.
Yes.
Threatening someone's dogs, is that an example of someone using control?
Yes.
Taking car keys from the other party, is that an example of control?
If they're withholding, yes.
Taking a phone and withholding a phone,
Yes.
a debit card,
Yes.
destroying a home, TVs, putting holes in the wall,
Yes.
not helping pay the rent and other bills.
So I would say that that could be withholding, that could go under coercive control of another person.
What about violating a court order to have no contact with the person?
Yes.
That's all the questions.
Thank you. Can this witness be released?
As far as the state is concerned.
Mr. Owens?
Yeah.
Thank you, doctor.
Elf points out
Collect all your stuff, ma'am. No worries.
that Joel from STS is in the room, and he said that there's a juror on the jury that admitted to a DV issue, and both sides were aware and picked her per Joel. And that's, yeah, if they had admitted to it, they were truthful on their questionnaire, and both sides had the opportunity to question that juror about it, then yes, that's fair, right? But if the juror lies about it and then it's found out later they lied about it and they didn't have the opportunity to question them about potential bias, that's a problem, in my opinion. Thank you, Elf, for your super chat. Just be glad I don't play this glare super chat song. I think we got a super chat.
Yes.
Please ask Attorney Todd about what now? About what communication regarding interview? What are you talking about? Whoop, whoop.
I got a couple things. I got 4:01. At this point in time, we're going to go ahead and take that afternoon break. I got a couple things I got to address with counsel as well, so maybe a little bit longer, but we'll bring you back in as promptly as possible. Again, same instruction I've given
How
you
late
before.
are we going, man?
Please don't conduct any independent investigation or research as the person, places, things, or charge involved in this case, and do not have any conversations amongst yourselves or anyone else about that. We'll bring you back in as promptly as possible. Thank you.
All right.
I thought it was their last witness, but I'm not sure. Well, there's going to be a rebuttal.
Y'all can be seated. Let's go ahead and take a recess a comfort break for any of us, and then we can address any argument with regard to the
I don't like that
any
either.
other evidence that the defense may be seeking. Let's come back here in about 10 minutes, so 4:13. Okay? All right, thank you. We'll be in a short recess.
Kind of like comfort break either. I'm with you. Whoever said that earlier. I'm not a fan. Not a fan of the fan.
Previously with domestic.
We don't need to listen to Jesse Weber. We're a little bit behind. A little bit behind. Oh, does the state have a rebuttal forensic psych? I don't know. They may have. We'll see. They had some things lined up for the rebuttal. I think we're going to see about it. They really do use the entire day. This is not Judge Beverly Cannoni's courtroom in Norfolk, where every other day was a holiday and summer Fridays and 2 for Tuesdays and early get out Thursdays. This is, they go till 6 a lot. And this may be over. It could be go to the jury by tomorrow, maybe. David says some of the things the defense asked the psychologist was not testified by Boone. She never said George took her keys or debit card away. She said he would take them to go buy alcohol. Right, correct. I agree. It was kind of a mischaracterization. A rebuttal, Leanne, is when the state gets to come back and call additional witnesses in rebuttal of the witnesses who just testified for the defense. So witnesses that will counter what the defense witnesses said or testified to. Rose says, here's a thought. The way her attorneys are with her is how the jury's going to interpret that. We've seen him strictly pointing when talking to her. Here we have seen him. I'm not sure what that means. So, Leanne, that was the answer to your question. Can anyone on the jury have been in a DV situation? Yes, as long as they were honest about it on their jury questionnaire and had the opportunity to be questioned about that. Thank you, Sarah Fitzgerald, for becoming a new member. I appreciate you. Court usually ends. They've been going to like 5:45 Eastern or 6. It is now 4:09 p.m. Eastern. Rachel already took a comfort nap. To be honest, I did during lunch. During the lunch period, I was so tired. I was up so late last night. And just like an hour. But you know, you like take a nap, but you're not really fully asleep, but it's still restful when you wake up. You're like, oh, that was great. It was good. It was good. But when you start dreaming about these cases that you're covering, it's a little weird. Like, really, do I need to be dreaming about what's happening in Sarah Boone's case? Oh, Jenna, can you guide us through a meditation? That would be amazing. That would be amazing. Yeah, the best power naps. Power naps are good. I've just been alerted also that Karen Reed's team has filed a reply brief in the appeal. So if I can get my hands on those papers, that's some more things we can look at in addition to the papers in the civil case. So many things and stuff to do and talk about. What do you guys have on your minds? Well, let's take this banner down because Julie Harper is no longer, Dr. Julie Harper is no longer on the stand. He was also abused. You talking about George? Are we talking about George? Yes, please. Oh, you're so polite. Alternate juror 3. Yeah, Amy's like, I fall asleep listening to these things make for trippy sleeps. Yeah, you got to be careful what you fall asleep to because I sleep to rain sounds. I like rain sounds. I put the rain sounds on. I like falling asleep to the sound of rain, the rain. And it helps. And then you get addicted to having the rain sounds playing while you go to sleep and you can't sleep without them. I am baffled. I sympathize with DV. I truly do, but I just don't see it here. Seems manipulative and controlling. They abuse each other. I'm just going to toss it out there that both things can be true, right? She could be a victim of DV. She could also be guilty of second-degree murder. Both of those things can be true, right? It's about whether or not the jury is going to buy her affirmative defense of battered spouse. So both things can be true. She could be a victim. We don't have to say she's guilty of second-degree murder and therefore she's not a victim. I think we can say, or the jury can say, they were mutually abusive. Mutually abusive. I do think that in Johnny Depp and Amber Heard, I think they were mutually abusive. I know that's an unpopular opinion. That's mine. Well, let's do a poll, Rara. Let's wait to do a poll until after all the evidence is in, after we see the rebuttal case, you know? Right. So, right, Jenny. I wonder if a lot of us agree on that and we are not that divided. Well, JD, here's the thing. Both of those things are true. She was abused and she committed murder, but murder requires, second-degree murder requires a depraved heart. A manslaughter would be a lesser included charge, which would not require intent, which could just be negligence. I could see the jury finding a negligent homicide type of charge, like or a manslaughter that requires negligence instead of intent, or a depraved heart. So I don't know. And that's why I'm not on the jury, and I'm glad I'm not, because this is the hardest case. I thought this was going to be really easy. When I got into this, I'm like, this is going to be easy. It'll just be, you know, it'll be fun to watch, and it'll just be an automatic guilty, and we'll be done here, and that'll be it. Genevieve 127, I like Dunkin' Donuts too. Don't tell anyone I know. I think Starbucks coffee, first of all, is too bitter. It's also too expensive. For what it is, I think it's that great. If I go to Starbucks, I get iced matcha latte, skim milk, light ice, and that's really delicious. But you know, $10 for a cup of coffee practically around here. That's right. Don't diss other creators that I collaborate with, because those comments will be deleted. Thank you, Sarah Fitzgerald, for becoming a new member, and I appreciate you so. And I would expect the same of other creators whose channels that I go on. If people disparage me in the chat, I would not want that. Would not want that to be left up. Thank you so much. Thank you so much. Just an observer. My Boston accent's coming along beautifully. Hollywood hardly ever gets it right. I know. They don't. Norfolk. It is Norfolk County. Jenny agrees with me. Deb and Heard were both abusive. Thank you. Thank you, Jenny. I saw someone in this chat saying that that they thought, I don't know who it was, and it's too late to highlight it now, that they thought that Sarah Boone's black eye photos were makeup. Didn't she testify those were taken in the hospital? And didn't we hear from the deputy? I don't know. I'm not going to go that far with this. Kiki Kazoo agrees both can be true. You know, I think once you factor in the alcoholism here, it's incredibly volatile. David says, in my opinion, she had a depraved heart. Great. And that's why the jury instructions are going to be so important, because the judge is going to define depraved heart. They're not going to let the jury decide what depraved heart means. Like in a recent trial that we watched where they didn't define reasonable doubt for the jury, because the judge said, no, I'm not going to define reasonable doubt for the jury because it's obvious what reasonable doubt is. Well, it really wasn't. So, great point. Moon Goddesses says, I can see negligence and a depraved heart. That's funny. I thought this specific murder 2 charge does not require intent, but it requires a depraved heart. But a manslaughter would be lesser included. How do you spell Mishigas? Mishegas? Egoss? Yeah. Mishegoss. If you would like the definition of that. From the Yiddish, I say it means mess. Let's see what Google says. Craziness, senseless behavior, or activity. Mishigas. Your Yiddish lesson of the day. Oh, Kimmy, you do? That's your sleep sound? Prop plane engine? That's interesting. Leanne would hate to make a decision on this. Kiki agrees Starbucks is expensive and not good. We don't know. Murder 2 is the only charge right now. Tomorrow there will be a charging conference, and sometimes they agree to lesser includeds. We'll see. Defense did not close. We're on break right now. We're on comfort break. Then they have some things to discuss, but the jury has not been dismissed for the day. after this, after the defense closes, then the state will put on their rebuttal case. So we're not quite there yet. Does she go to prison there? Like the nearest one? Well, she would not go to prison until after her sentencing. So she would go back to wherever she's being held. I think she's being held, I don't know. You can correct me if I'm wrong. Orange County Correctional Facility. I don't know. I don't know where she's being held, at the county jail. After sentencing is when you go to prison. And that's what the crazy stuff about what's going on in Delphi is that Richard Allen has been held in prison this entire time. Not jail. In what many say are inhumane conditions, and he's not been convicted yet. So it's crazy. He's a mensch. He's a mensch. This is Allie. Costa Coffee. It's a coffee shop. I do not know about Costa Coffee. Or are you saying it's a brand of coffee that you can buy in the store? Bilateral music. I don't even know what that is. Cammie. I don't even know what that is. Orange County Jail in Orlando. Thank you. Thank you, Kelly. So collaborative, all of you. If I were Brian, I'd be meeting with an attorney for sole custody. Prison is better than jail. I don't know. Delphi, they said the jail warden said he couldn't properly protect Richard Allen. People have a lot of conspiracy theories about that case. Not conspiracy theories, but other theories of, they got the wrong guy. A lot of people who are looking into it now for the first time think it's way more sus than the Karen Reed case was. Even Suzanne says the Delphi case blows my mind. They finally did move him at some point, but it was a couple of months ago. I think he was arrested in 2022, which was 5 years after the murders. So that's interesting. Thank you, Rose. I do love that we're able to have our own opinions and be respectful. Sorry, I need to put chicken wings down so I can actually type. It's okay. Oh, you're going to make me want chicken wings now. I think we have a super chat. Yeah, I can't wait. Watch Allie from Defense Diaries. She does a great update because her husband, Bob Mata, is in the courtroom in Delphi. Also, Lauren from Hidden True Crime did a great update last night that I listened to. Andrea Burkhart is also there, and Lawyer Lee. I'm interested to see what happened with Andrea Burkhart's motion that she made for the public to be able to see the evidence, because that case has been under some serious raps. I mean, everything's been held. There's a gag order. That judge tried to take away Richard Allen's attorneys. And then it went all the way to the Supreme Court of Indiana, and they overturned it. So that's interesting. I wonder, Renee, if the previous 8 attorneys are watching here.
Case number 2020 CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Nick Castor on behalf of the state. William J.
Defense.
James Owens for the defense.
Tony Henderson for Sarah Boone.
All right.
Andrea's
Ms. Boone
motion
is seated at counsel's table wearing the same.
Before that person yells at me again for talking over the testimony, I'll pause it and we'll just sit here and I'll turn off the air conditioning. It was denied. Andrea's motion was denied. I haven't even looked at, oh wait, it was denied. And then someone says it's stagnant and she hasn't looked at it yet. So, okay. Here we go.
Gray suit and maroon blouse from this morning. Mr. Owens, are there any other matters we need to address before you rest in the presence of our jury?
Yes.
Yes, sir.
Mr. Henderson.
Yes, sir.
Judge, there's 2 orders that I'm going to be requesting the court to take judicial notice under 90.202 sub 6. And the orders of no contact. I have copies of the certified copies of the orders. May I approach?
Yes. State, have you seen them?
Doesn't change my position.
Understand, but you have seen them.
I have not.
You have not seen them. Okay.
Allow
Doesn't
it.
change my position.
Understood. Okay. You can bring them on up.
Did he just snort into the mic?
Thank you, sir. 6-2 on or about No contact orders issued has been provided. Court has been provided. No contact orders issued in case number 2019 MM5062 on or about June 16, 2019, and a no contact order in case number 2019 MM5114 issued on or about June 19, 2019. Both cases styled State of Florida versus Torres George Jr. Let me hear any arguments as to the judicial notice from you, Mr. Henderson.
Judge, I think they're relevant. I think just from the testimony of Director Dr. Harper, saying that an element of control, the control is talked about greatly by the state, when I point out things hypothetically that they refer to. They refer to them as hypothetically. However, they refer to things that they're developing on this Boone. These show that they were in fact orders, and the orders were for no contact. So these are elements of control in relation to George Torres.
Okay. Response.
So in regards to the judicial notice aspect, we don't dispute that that can be a substitute for authenticity. However, they're not relevant, they're not admissible. They contain statements that were made by people who are not testifying. Just because an expert relies on something doesn't mean that it's admissible. What happened during redirect with Mr. Owens was he was asking, what are the hypothetical things that we rely upon in making these determinations as an expert about whether there's battered spouse syndrome or not. So one of the many inadmissible things that he mentioned was pretrial orders of no contact. So it's fine. The expert can certainly rely on the fact that there may have been pretrial contact orders or no contact orders that were involved in this case, and she considered that. That doesn't make them admissible. There has been testimony, I believe, from Ms. Moon that there was pretrial no contact orders and violations of them. It's not a fact in dispute. It's just that doesn't mean that the paperwork comes in as evidence. So that's our objection, is it's irrelevant and hearsay. Just because an expert relies on inadmissible evidence doesn't make it admissible.
What's your response to hearsay?
Judge, I think under the, as to hearsay, I think the statute takes care of that itself, because it says that the court can take judicial notice. So that's the foundationary part. And it's not hearsay, it's an order of the court. We're in a case where we've gotten evidence of past domestic abuse. There was evidence of it, started with the state, about control. And these are things of control. And I'm sure the state's going to, in rebuttal, they're going to come up with things that they feel either by body cam or any other evidence that shows her exercising control. This shows Mr. Torres exercising control. It is very relevant.
Okay. But how's it not hearsay? Just because it's a court record, it's still out of court statement. It's certainly being offered for the truth of the matter asserted. No contact order.
Judge, that's why we have the thing that the court could take judicial notice of. There are certain things that court.
But the case law says you can't utilize judicial notice to get around hearsay. I know 9202 says that I may take judicial notice.
That's what he's asking you to do.
9203 says that upon sufficient notice being provided, which the state is conceding based on their argument, the court shall take judicial notice of items identified in 9202. But my question is, the case law, as identified in Professor Earhart's treatise, specifically says in Dufour v. State, 69 Southern 3rd, 235, which specifically talks about notice of judicial documents in a court file, that doesn't get you around hearsay. So what's your response?
Let me go through hearsay in my mind again.
You're fine. Take your time.
He needs a minute. They're saying that during the redirect or the cross of the expert, because the state kept bringing up the issue of control, as being a factor in these diagnoses, that they now should be able to show these restraining orders or no contact orders with regard to George. I don't know who had the contact orders. I don't know if Sarah had restraining orders against George, if other people had restraining orders against George. I'm not sure. If George had restraining orders against Sarah, and they're saying that was his way of showing control over her.
Judge,
Yes.
I'll start this way first. One of the exceptions to the hearsay rule is business records exception. So if it's a business record and it's kept in the normal course of business, then someone can come in and lay the foundational things for the business record exceptions to the hearsay rule. However, in this case, that would not be needed if the court takes judicial notice of it. That eliminates the necessity to do a business record in that foundation, because the court, under the statute 90.2026, can take judicial notice of court orders. This is a court order, it's certified. I think it's an exception to the hearsay rule. Also, I think the probative value of these documents outweighs any prejudicial effect.
Any other argument?
No, you're right.
Any other argument, State?
The fact that there was a pretrial court order of no contact between them is going to come in. I mean, on one of the body worn cameras, Mr. Torres is like, well, you know, the court said I couldn't, but she said I could come. And I believe she testified to that during her examination. My objection is to the paper and the grounds that I've argued.
So she had orders of
Thank you very
protection
much.
against him. That apparently in the body cam footage that they're probably going to show during rebuttal is going to show George admitting that he knows that there's an order of protection, but she said I could come over. See? And he's saying, well, we're not objecting to the fact that there was restraining orders against him. We're objecting to the paper of the restraining order coming in.
State v. Mobley, 98 Southern 3rd, 124 by the Florida 5th District Court of Appeal, cited in 2012, says that there's a procedure that specifically needs to be followed for judicial notice, as set forth in 9202 and 9203. State is conceding that although there's not a writing, they're not objecting to the judicial notice concept. They're objecting to the evidentiary bases. I do find that it is relevant, but the problem is I have with hearsay. And court, in relying on the Florida Supreme Court decision in Dufour, D-U-F-O-U-R v. State, 69 Southern 3rd, 235 at pinpoint 253 by the Florida Supreme Court in 2011, which states, while the court may take judicial notice of documents in a court file which were properly placed there, this notice would not make the contents of the documents admissible if they were subject to challenge, such as when a document is protected by privilege or constitutes hearsay. It is an out-of-court statement that is being offered for the truth, to wit, it is a no-contact order, and the requisite requirements for a business record under 98036 subsection A have not been met, nor has there been a certificate from the custodian of records as to those things, as required by section 6, paragraph C, and the timeliness of a certification. So I cannot accept judicial notice of these two documents, even though the state is not conceding the procedure for judicial notice. I am sustaining the state's objection as to hearsay under the grounds and the exceptions that you have offered.
Okay. Why would the paper matter, says Elf? The paper would matter because that is something the jury can bring back with them during deliberations. It would be entered into evidence. There also may be statements, without seeing the order, it's hard to say, but there may be statements in the order, allegations, things that the Sarah Boone said in order to get the order of protection. That could be statements that are not exceptions to the hearsay rule. Hearsay is something, or an out-of-court statement that is offered to prove the truth of whatever is in that statement. And the judge is saying, I mean, if they called in a custodian of records for the court, then he would let them in. I don't know. I don't know that I agree with his ruling, but he's on top of his case law. He's got his laptop right there. He's got all his cases at the ready. He's definitely prepared. And he rules from the bench and he doesn't take things under advisement. He doesn't get tired and go home and take a break. But they're going to be able to discuss the orders of protection. So, I mean, that is, I guess, fair to the defense in a way. I don't know if I agree with this ruling, though. And we've seen the lack of enforcement of orders of protection in Florida. We saw it in Ashley Benefield. They didn't care. She went in with an order of protection to the officers in Florida with the North Carolina order. They didn't care. They're like, go away. It's a piece of paper. We don't care. Kind of, sort of like that. Remember that sheriff or whatever he was that testified?
Somewhere in this building. I believe they sent some message to us back before the hurricane about what they needed to come, and we said to be continued. So we haven't gotten back up with them yet. So
The courts were closed
it would take
after the first hurricane. I think it was Helene, right? The courts were closed in Manatee County. Even the website was down for at least 2 weeks. So I don't know what court these are from and whether they've been trying to contact someone and their operations are not yet up yet. I mean, that's a good excuse too. Like we were trying to get someone to come in and authenticate these records for us and testify that they're official business records. But, because of what's going on with the hurricane, we can't. We'll see what he says.
some time to check on that. It's 4:30.
Was the subpoena still for this time period?
Yes, I believe it was a 3-week period,
Okay,
but we haven't followed back up with them. This came up
sure.
late.
I'll give you an opportunity to do that.
And the case, remember, this case got pushed. This case got pushed at least a week. They were supposed to select a jury when the hurricane was coming, and they put it over for at least a week, remember? Oh, so he's going to allow it. All
I
right.
don't know whether you could just go ahead and send them to home for the evening, and let me see if we could find the clerk maybe in the morning, and then we could rest in the morning, and then the state has Dr. Werner.
Yeah,
This is
do that.
probably gonna take me a little bit
Yeah,
to find.
I'll give you that opportunity. Absolutely.
Very nice.
If you want to, sure. If you want to try to do it now or do it tomorrow, I'll leave it to you. Because I can't imagine it would take long if we're able to get a records custodian or a person
Very fair.
To lay the foundation. I can't imagine it would take that long.
Aren't they in the building?
Yes. 3rd floor?
They're in the building. You can just bring somebody down from the records office to say these are official court records, and then they get in. See how easy and nice trials can go when the judge is fair and everybody works towards a solution together and the attorneys stipulate to things coming in.
Sure.
It's crazy.
I suggest we go ahead and let the jury go. It's 4:30.
Okay.
I don't know how long it's gonna take to do that, but we could present that in the morning and then rest in the morning and then they.
All right, that works for me.
Judge, I'm not gonna make some poor employee come in and do that. I was conceding the authenticity. I just don't understand the relevance of it coming in.
Are you now withdrawing your hearsay objection?
Well, I still believe it's hearsay, but I think it's cured by, it's a public record and it's stamped and all that stuff.
I know, but no one's made that argument yet.
I don't want to punish some poor clerk.
Okay.
He doesn't want to punish a clerk.
I won't object to them coming in, but it's a slippery slope for other records. We'll see what we do as well.
Okay. All right. So the state is still maintaining its hearsay objection. I do find that it is relevant.
But I don't want to make my argument.
So then what do you want to do, Mr. J?
I'm stipulating to, if the hang up for the court and the defendant is that they believe a clerk in the court needs to come in and testify, I'm conceding that issue so that person does not have to do whatever that issue is.
Okay. All right. Fine. Then based on the court, on the concession by the defense, by the state, excuse me, do you have any other objections with regard to these 2 non-contact orders? Mr. J?
No more.
Okay. For the reasons previously articulated, I do find it's relevant. The state has withdrawn its hearsay objection. Do you want these as a composite or individual?
Individually.
Okay. Madam Clerk, could you pre-mark them and then we'll identify them, please?
Oh, in real time?
No contact order in the no contact order in 2019 MM 5062 dated June 16, 2019 has been pre-marked as AB. And the no contact order in 19 MM 5114 dated June 19th, 2019 is dated as AC.
So there's 2 orders within 3 days of each other?
Mr. Owens, you can approach. Let's just tackle a couple other housekeeping matters that we have. You can move those in when our jury returns into evidence. Are there any other witnesses, evidence, or testimony, sir, that you're going to be offering this afternoon?
I don't believe so, but we're intending on resting either this afternoon or first thing in the morning, but we want some time to talk to Sarah Boone and explain to her, why we think we should rest, not call any further witnesses, not introduce any other exhibits, just to make sure that we're all on the same page with her about what our strategy is. So we need a little bit of time. I don't know if you want to go ahead and excuse the jury for the night and then have us come back in the morning and do that colloquy with the court, with the defendant. But we do need some time with her.
Okay. All right. So then here's what we'll do. I'll bring in the jury and I'll excuse them. You can save those pieces of paper and you can move them into evidence tomorrow morning and then present. That'll work. Thank you, Madam Clerk. We'll bring the jury back at 9 a.m. tomorrow, and you can continue with your evidence presentation at that time, including but not limited to calling any additional witnesses. Court can have any further colloquy with the defense at that time. The state then can put on its rebuttal case. The state, how long do you anticipate ballparking it for the court, your rebuttal case?
I don't believe Dr. Warner will take long on our part. I'm not sure how long it will take on their part. And then there's about,
How long is that for your part?
I'm not going to hold you to it, Mr. J.
probably less than 30.
How long do you anticipate your cross being? And ballpark it. Again, I won't hold you to it.
His direct is 30, my cross is probably going to be 30.
Okay, what else do you have to present?
And then there would be about 2 hours of videos from body worn camera and from the phone extraction.
Mhm.
And then reading a good bit of phone text messages with the record.
Separate and apart from the 2-hour video presentation. Okay, got it. All right. Okay, so that's going to take us in tomorrow afternoon. Are we going to be in a position for the state to rest its rebuttal case tomorrow and proceed with closings? Or are we going to proceed with closings Friday morning after had the opportunity to have a full, not that we would not have a full charging conference, but after having a charging conference Thursday afternoon with regard to the jury instructions?
I just don't know how long. I think all the instructions are pretty relatively simple and straightforward, except for 3.6.
Agreed. 3.6F. I agree.
That's not going to be simple or straightforward in any way.
The instruction is complicated. I agree.
And the special jury instruction on battered spouse that we're going to be requesting.
Okay.
There's different courts, Judge, here in Florida that have used the special instructions. There's different courts in other states that have used a different instruction. We've looked at a bunch of them, so I don't know what this court is going to be inclined to do if court will be so inclined to give a special instruction on battered spouse, whether or not you want to consider one of the local courts, the Palm Beach County case that I mentioned before with Dr. Brennan. There was a special instruction in that case. And then we've got some from other states. I don't know what the state's position is going to be on that. So we may,
Has a draft of that been circulated yet?
not to the court.
Okay. All right. All right. So here's what we're going to do. Okay. Let's just see how long the rebuttal case takes. And then if we have to do closings Friday morning, we'll have to do closings Friday morning. I'd rather go through and spend the time to make sure that we're all on the same page with regard to the instructions, especially due to the complicated nature of 3.6F. With regard to those, the court will have Ms. Barrios email you all. She just started her drive back to Kissimmee, so it might come a little bit later this evening. I will have Ms. Barrios email to you all the red line that the court has worked on so far of the jury instructions provided by the state. The defense is to provide its markup of the 3.6F and 3.6G instructions and any other defensive instructions that the defense seeks to have read to the jury.
Before 9 o'clock in the morning?
I think so. That gives the state the opportunity during the lunch hour to review them in advance of our charging conference.
I'll have it done before 9.
Okay.
Judge?
Yes, sir.
There was one thing, the state had filed a motion requesting a special instruction as to, I think it was the voluntariness. I read the motion and the proposed instruction. I have no objection to it.
Okay. All right. So just so the record's clear, we're referring to the state's request for special jury instruction regarding Florida Criminal Standard Jury Instruction 3.9B, defendant's statements, filed October 22, 2024. The provision that the state seeks to add to the 3.9B instruction reads as follows: law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. The state defense state, have I read that correctly?
I believe so, without reading myself.
And defense, you have no objection.
No objection, Judge. And it's my understanding that's going to, there's already the standard instruction. That's an add-on to the standard.
It's just a matter of where y'all want it. So I will add this to the red line to be set out this afternoon. Ms. Boone, I want to have a couple other conversations with you, ma'am. Again, I don't want to know specifics of anything that you or your attorneys have discussed, just whether or not you've had those discussions. Did you hear the court read the proposed additional language to the jury instruction
Like, I
about
wasn't paying
your
attention.
statements?
Just now?
Yes, ma'am.
Could you please read it one more time?
I can. So just to give you some background, ma'am.
All right, everybody, listen up, because this is going to be important too. This is why the jury instructions are so important in every case. And Iceman says, to be fair, outside of Canton and the YSL judge, we've seen some darn good judges. Judge Summer from Alec Baldwin trial, amazing. Judge from Depp v. Heard. Judge Madonna lady from Will and Grace. That was the Robert Tellis judge. Her name is Judge Michelle Levitt. I love her too. All right, listen up.
There's a form instruction. It's 3.9B, and it talks about how the jury is to consider your statements that were read to them and provided in evidence through the course of the trial. And that they're to consider the voluntariness of those statements and whether they were coerced. The state is seeking to add the following language to that instruction. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Do you understand that portion of the instruction?
Yes.
Do you have any questions about it?
No.
Okay. Have you had conversations with your attorneys about the proposed additional language that I just read to you?
Not yet.
Okay. Let's go ahead and have those conversations tonight when you all break, and we can go over this tomorrow when we have the charging conference. But I'll go ahead and add it to the red line for the purposes of our discussion tomorrow.
Thank you, Judge.
Okay. Anything else, state, we need to address?
No, Your Honor.
Defense, anything else?
No, sir.
Okay, let's go ahead and bring our panel back in, and we'll tell them we'll commence tomorrow with additional evidence and testimony at 9 a.m.
So the rebuttal case will
Again,
be
could you just
tomorrow.
raise those hands, confirm that you complied with the court's instruction. We're going to go ahead and break for the evening. I'm going to ask you to be back here at 9 a.m. tomorrow morning. We'll continue with evidence and testimony presentation by the defense, and then we'll proceed accordingly thereafter. I want to read you the same instruction that I've read you multiple times over the last week, and I beg your forgiveness as you hear it again, but I just have to keep reminding you. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device,
We all will,
or any other
Kathy.
means at all. to get information related to this case or the people home or anywhere else. Look at your
behind.
not.
All right. Don't do all the things and stuff that you're not supposed to do, jury.
Court's off the record.
All right. Tomorrow at 9, we'll be back. Let's take some questions. For those of you who are saying, oh, I wish you would have covered the fire pit trial. Next time that you guys know the trials are coming up that you're interested in that are going to be televised, that's the important thing, because there's a lot of these are not televised, and you find them to be more interesting than the one that we intend on covering, like the Sarah Boone case, let me know. Email me. Let me know. I'm open to all suggestions. And sometimes, like, when too many people are covering a case, it's like, I mean, look, this has not been a huge viewed trial on this channel. So if there are a lot of people that are more interested in another trial that nobody else is going to cover, let me know. I'm totally open to suggestions. The email is somewhere, fanbase@mlittlelaw.com. It's fanbase@mlittlelaw.com. So likely Lonnie Simon, that would have been a good one. The fire pit trial, that would have been a good one. But we're here and now we're invested. We got to get done with this. Chief Duck Worthless, thanks for becoming a member. Courtney W., thank you for gifting membership. Hello, Jenny Grace. Tried to keep up during travels, way behind. Yesterday was funny, albeit rude, when you were called out for volume. Not your fault. You're an outstanding whisperer through. Was it yesterday? I don't think that was yesterday. I think it was a different day. But thanks, Jenny Grace. So very torn on this case. I know. I think a lot of people are. I know. Like Crystal said, I wish Melanie was showing the fire pit trial. Supposedly the wife shot the husband and put him in the fire pit. Love her opinion. No, sometimes you don't even know. You don't know how good a trial is going to be when you get into it. And sometimes you get into it and the audio stinks and the court feed stinks. There's not a whole lot that we can do. Right? Here it is. Thank you. Thank you all. All right, everyone. I will see you tomorrow. Hopefully they say hopefully the rebuttal will be done tomorrow. It looks like closings are going to be Friday morning. So we are going to thank the moderators for being here. They are amazing. They keep this place and make this place what it is, and a fun place and a nice place and a kind place for people to be. I will see you in the morning. If I'm able to get a hold of some Karen Reed appellate paperwork, we may do that later. We may do that tomorrow during lunch. You just never know what's going to happen here. It's like every day is a new day and an adventure. It's an adventure always, always. So make sure that you hit the subscribe and the bell so that you will know if and when I go live, because it's often on the spur of the moment, as you know. Thank you, everyone, for your support. I love you. I will see you. I'll miss you until tomorrow. As somebody said, when are you going live with the glare again? It's his turn to invite me. So tell him to invite me and I'll go back over there anytime. Peace, my friends. Be cool, be kind, stay cool, kind, and classy, and I'll see you in the morning.